roof. The aluminium framing is the property is this one just here. You can see that the conservatory itself is screened by this rear extension to the neighbouring property, and the conservatory is not visible from the street scene. What we have in front of us is a retrospective application for development that's taken place. It's not a planning application. This is for listed building consent, and the council's conservation officer has raised an objection to the proposal. There is a concern about cumulative enlargement of the terrace. There is a single-storey flat roof extension already to the rear of the property, and then the conservatory comes off a further 2.7 metres from that flat roofed extension. So I'll just refer you to the update sheet. The update sheet provides a correction or an update to the table on page 10 in combination with the existing extension, the existing flat roofed extension. There's a 4.4 metre net gain in depth from the original dwelling of the existing and proposed extensions. While we're on the update sheet, I'd also refer you to the correction to the informative on page 15. Now, the fact that the conservatory is not visible in the street scene is obviously an issue in terms of arguing impact on the character of the area. The advice that we've received from the conservation officer is that the fundamental issue that we're looking at is the relationship of the extension to the listed building. The listed building is a heritage asset, and the cumulative enlargement in the way that's taken place is considered harmful and detrimental to that heritage asset. The recommendation before you is for refusal on the basis of that harm to the heritage asset. The application has been referred to committee by Councillor Hall, who disagrees with the refusal recommendation, and the application has been delayed or held in abeyance to enable the applicant to address the committee. The issue about the cumulative enlargement and impact on the heritage asset, as I say, is the fundamental issue before us. There is an informative that refers to the need for planning permission, which is separate to the listed building consent that's in front of us. So the recommendation is to refuse the application. Thank you.
Thank you. We have one speaker on this. It's Mr. Bateman. If you'd like to come up to the table at the front, please. If you could turn your microphone on, and then I'll give you a minute or so to introduce yourself, and then we'll start the clock.
Okay, I'll turn it on. My name's Ian Bateman. I'm just speaking on behalf of Mrs. Kim Bicknell, who is the owner of 11 Silver Street, my partner. I'll be discussing comments that I've got about the refusal. I should like to say that I'm disappointed with the council choosing today for the meeting. Councillor Hall isn't here, and I was only told that yesterday. I was only told he couldn't be here yesterday. I asked for the meeting to be deferred, and that was refused. So we have to go on. I would also like to say that comments against my application were due on the 20th of March, but the Conservation Officer failed to submit her comments until the 23rd of March, which I find a bit odd. However, still, we go on. So 11 Silver Street is a 19th century cottage, and it's surrounded by 20th and 21st century cottages. It is a lovely little cottage, but because in the 19th century houses were not so large, it is 2 bedrooms upstairs and 1 lounge downstairs. It has a kitchen extension which was built in 1960. It's a small house. It's not very user-friendly, you would say, for 21st century living. It's got no dining room, nowhere for children to play, nowhere to sit. It cries out for further development. I understand fully that the need to preserve the look of Silver Street. And if you look at my house, 11 Silver Street, you'll have noticed it's called Rose Cottage. I've got some photographs, I'm not allowed to show them, but it is looked after tremendously well. So we built the extension without permission. We didn't know we needed listed building permission because it essentially sits on a plot which was a scruffy brick paved patio, and it doesn't become, it's nowhere close to the listed building itself. There's the extension which was built in 1960 itself is an ugly extension, but this is what we have. So I'm only asking for listed building application refusal being overturned. If it's not overturned, there's no point me going for planning permission. It's a waste of time, waste of everybody's time and money. So I'm asking for, as I say, I'm asking for it to be overturned on the grounds of amenity. It extends the usefulness of the house, makes it far more desirable to living in the 21st century, and in fact it enhances the property. I don't need the last 10 seconds.
Thank you very much, Mr. Bateman. We'll now go into questions. Do any members have any questions? Councillor Grace.
I noticed that there were 2 letters of objections. Were they from the neighbours, or were they local to this property? I actually know the property very well because my friend used to own it about 10 years ago, 8 years ago. So I have been inside it, and I know how it works. So I just wanted to know who objected to this.
I think that would constitute a non-pecuniary interest for present purposes.
Yeah, thank you.
Yes.
Through you, Chairman. The 2 representations were from properties either side of number 11. As you'll see from the report, they raise concerns about overlooking unattractiveness of the structure, impact on outlook and noise disturbance, and also concerns about the party wall. These are mainly matters to be addressed under a planning application, but the proposal, as I say, is an application, retrospective application for this building consent.
Vice Chairman, Councillor Barr.
Thank you, Chairman. Given the extension on the property that goes along Wick Lane, which we can see on the pictures there, if a similar extension were proposed for this property, I know obviously it would be a different application and you probably can't actually comment, so it probably may not be worthwhile asking the question, but I just wonder whether that would have been more appropriate than what we see in front of us.
Through you, Chair, the extension you can see at the rear of that property does benefit from consent. The consent stipulated the relevant materials, but as you're aware, it's a different context, that property is larger in terms of its curtilage and has a different physical relationship. Sorry, through you, Chair, again. The reason for refusal relates to the design and materials, and that's the reason I was mentioning the characteristics of the adjacent property.
Councillor Neil?
Well, as a heritage champion, I've got to support the conservation officer. I feel that if and when it was bought, the occupant would have known that it's a listed building, or should have known it's a listed building, and therefore I'm going to propose as set out.
Jump from questions to debate. That's absolutely fine. Councillor Neil has proposed. Do I have a seconder in the room? Councillor Bath?
I can quite see why Mr. Bateman and Mrs. Bignell must be very upsetting for them, because this is an expensive extension that they've put onto the back of their property, and I do feel for them. But I think Councillor Neil is right. We have a conservation officer. She is our professional in this, and our heritage assets are something that Christchurch is renowned for. And unfortunately, I do feel that we should go along with our officer's recommendation for refusal on this one. So I'm happy to second the refusal.
We have a proposer and a seconder to refuse this application, so I'm going to go to the vote. All those in favour of refusal, please show your hands. Any against? Any abstentions? One abstention. That application is refused. Thank you very much for coming along, Mr. Bateman. Yeah. We're going to take a slight adjournment for a moment. Thank you, ladies and gentlemen. We're going to go on to items 4B and 4C, which will be presented as a single item. However, we will then have separate public speakers on the first item, which we will then debate and vote on, and then we will have public speakers on the second item, which we will then debate and speak on. Who's speaking on this one, please? Thank you.
Good evening, members, ladies and gentlemen. This application, this pair of applications, are complex, and you will see from your agenda that we have set out in considerable detail the issues surrounding the proposal, and members will also be aware that this is a site that this council has looked at on more than one occasion, and there are a number of outstanding enforcement notices in the site, and we have, I think it's 138 outstanding appeals with the Planning Inspectorate on this site, which haven't progressed very far, but they are still live appeals which have yet to be determined, and those appeals consider very similar issues that are before you this evening. In essence, this is a site that started life as a holiday site for accommodation in caravans for holiday accommodation, limited to certain occupation at certain times of the year, and not to be used as people's main residences. The conditions that the applications seek to remove basically go to the heart of those original conditions, those original planning permissions. We're seeking by condition to remove effectively the limitation on the site to be used for holiday purposes only, which would allow residential use of the site in the future, and there will be no limit to the time that the units could be occupied. The site lies within the Greenbelt in a relatively isolated location, and it is also within 400 metres of European protected heathlands where residential development is inappropriate. We've also got the fact that residential development is inappropriate in the Greenbelt unless the applicant has put forward very special circumstances to overcome the fundamental national policy that seeks to prevent residential development in the Greenbelt. We have had submitted to us, which are very handy, a series of photographs from representatives of the applicants, which very clearly show members the nature of the site before them. It is no longer effectively a holiday park. Most of the units are occupied permanently, residentially, to a very high quality. Residents are very look after the properties incredibly well. This is a very neat and tidy site. But we go back to the fundamental problem of the fact that it is a use that is evolved over time away from the use that was lawful in the Greenbelt. You have applications before you under Section 73 of the Town Country Planning Act. Those seek to vary conditions. This council has sought legal advice on how to deal with applications under Section 73 because of the complex nature of the site and the ongoing issues in respect of the enforcement notices and the problems associated with unauthorised use of the property. On that basis, we have had advice from our legal advice that this committee cannot grant the planning permissions that are before you, or the applications that are before you, because fundamentally to remove the conditions that are sought and these two applications would undermine the original planning permissions that sought to limit the use of the site for holiday use only and for time limited use only. So if you granted the planning permission for the applications, you would effectively allow an unfettered development in the Greenbelt within 400 metres of heathland for residential use. The advice we have clearly is that that you cannot do that because you're basically taking away the consent that existed in the first place, and that is not the function of section 73 of the planning legislation. You have two other issues on the site: the fact that it does lie in the greenbelt, and residential development is inappropriate and no very special circumstances have been put forward. You also have a fundamental objection from Natural England in respect of the use of this site within 400 metres of woodland. And as we've advised members before, if members wanted to approve the application this evening, you couldn't, because Natural England have objected, and planning permission cannot be granted by this authority without reference to Natural England to enable them to call the application in to the Secretary of State for an appeal. So that is one of the issues. So you would effectively end up with an unplanned settlement in a non-sustainable location if this development was allowed to remain. You've noticed on your update sheet that we would like to add the fact that this is inappropriate development in the greenbelt to the proposed reason for refusal number 2. But in essence, this is a complicated site, but there are fundamentally 3 issues, and those are the 3 that I've just mentioned to you. But this council doesn't really have the ability to grant a planning permission that undermines the existing consents that existed on the site, and also you have a fundamental objection from Natural England. Thank you.
Thank you for that presentation. We now have 4 speakers. I'm assuming they want to speak on both items. So I'm going to call you up, and then if you want to come back and speak again later, you will be able to. The first speaker is Mr. J. Kane, his planning consultant. Again, as with the previous speaker, if you take a moment to introduce yourself, and then we'll start the clock.
Thank you, Chair. James Kane, planning consultant. I'll be speaking as well with 2 local residents this evening. Okay, it is clear from reading the officer's report that much of what is written has been produced by the legal team of the planning authority, and that is understandable given the fact that there are enforcement appeals and lawful development certificate appeals currently being determined on this site. This is a very legalistic and technical matter with multiple strands. My clients have not had a full and proper opportunity to respond to what are in effect legal submissions in the report. The officer's reports only became available 5 working days ago, and this is insufficient time to obtain a full legal opinion with regard to the first reason for refusal in particular. This is disappointing, as it has been known for at least 2 months that the application was being determined this evening, and the planning authority should have provided more time for my clients to respond to the legal points made in the report. That said, I've been able to get an informal legal opinion on the section 73 point, and the initial conclusion is that this is a very arguable point. The main item coming out of the legal review is that the planning authority, if refusing permission tonight, cannot then insist upon the ground A appeal being dropped from the enforcement appeal. The planning authority are trying to have their cake and eat it in this regard. They cannot say that the variation of condition applications cannot be determined because they fundamentally alter the original description of development, and then insist that the residents cannot pursue a ground A appeal, the planning authority believing itself wide open to a challenge. Similarly, the Arrowcroft case is well-known case law regarding section 73 applications. The Arrowcroft case tells us that there are 2 tests in law regarding whether a section 73 can be determined. Firstly, does it nullify the original permission? Secondly, does it deprive those who wish to be consulted of a voice? It certainly does not do the latter, as you can see from this evening. Everybody with an interest in this land is fully aware. Your legal team will also be aware that there are 3 contradictory cases, known as the Powergen case, the Pike case, and another called Lawson Builders, which allow for a wide-ranging inquiry of planning merits under section 73. It would be premature of the committee to agree to refuse permission without seeing the alternative case law. That leaves the substantive planning issues, and I refer you to the Organford appeal decision, which is elsewhere in Dorset. The similarities between the cases are striking. That site was for a park hole within 400 metres of a triple SI, with a Natural England objection. The inspector confirmed that there was no material difference between a mix of holiday and permanent residents compared to 100% permanent residents. The applicants are asking for the same arguments to be considered this evening. Please allow residents a chance to put their alternative legal case forward. If you refuse permission tonight and then try to force the inspectorate to turn away the Ground A appeal, then the planning authority will be leaving itself wide open. Thank you, Chair.
Thank you very much. The next speaker I have on my list is our MP, Mr. Christopher Choate.
I'm Chris Choate, I'm the MP for Christchurch, and I've got involved in this issue because
Could you turn your microphone on, please? Sorry.
I've got involved in this issue because I was concerned that the appeals of the residents against the enforcement have still not been resolved by the planning inspectorate, and the planning inspectorate have decided that they're going to look further into the appeal against the decision that was taken in 2007, an extraordinary late appeal, but nevertheless apparently a lawful appeal. And the planning inspectorate asked, as you will probably know, for there to be testimony on oath in relation to that appeal. So these two very serious appeals that are continuing at the moment. And the reason I wanted to say something on behalf of these residents is that essentially nothing's going to change the character of this site. What we're talking about is who's going to be occupying these buildings. So that in terms of the green belt and natural England, it's not going to make a ha'porth of difference what happens, because these buildings are still going to remain there, whatever happens. And I think that should be taken into account. But the point I particularly wanted to dwell on was the letter of the 4th of July 2012 from Paul Bliss of the Stour Valley and Pool Partnership. In that letter, Mr. Bliss confirms, and I quote, "Having spoken to the relevant officers, the Valuation Office has brought 67 mobile homes into the council tax list with effect from the 21st of May 2012. He said that this had been done on the basis that the homes are owned and that the occupiers can reside on site for 12 months of the year. He also said that from a council tax viewpoint, sole or main residence has been deemed on the site." And he said, in that letter, he said that there had been a meeting between him and residents and representatives from the owners of the site on in June. So I then asked the Stour Valley and Pool Partnership who was present at that meeting on the 12th of June, and I've received a letter today dated the 18th of July 2017 saying, "I can advise you that the officers with whom Mr. Bliss spoke following the meeting on the 12th of June 2012 were officers of the Valuation Office Agency and Christchurch Borough Council's Planning Enforcement Officer." And I can't understand how, if it was the Christchurch Council's Planning Enforcement Officer who was consulted before that letter from Mr. Bliss was sent out, it seems to me that the council cannot now start arguing something completely different from what was being argued at that time by the council, namely that these were residents who had the right to stay there for 12 months of the year and were residential rather than holiday occupiers.
Thank you very much. Now going to ask Mrs. Miller to come and speak. Again, if you introduce yourself, and I'll put the clock on in a moment.
Thank you. My name's Mandy Miller. I'm the chair of the Tall Trees Homeowners Association on the park. And I just want to say thank you for giving me the opportunity to speak on what is obviously a very complicated planning application. We are a caring community who love and respect our homes as well as the surrounding environment, a consideration which might not be the case should Tall Trees Park formally revert to a holiday park. Should it be deemed that Tall Trees does revert to holiday use, the park owners may well apply for planning permission to build a clubhouse and bar, shop, children's play areas. The impact of these would be immense on neighbouring properties, and I think we could also be pretty certain that holiday makers would not have the same respect for the heathland that permanent residents have. Most homes are manufactured to a high residential standard with full insulation, central heating, double glazing. Many have 3 bedrooms, 2 bathrooms, with just 2 full-time occupants. As a holiday home, they would accommodate up to 8 people. They are not easily portable, and moving these could be tantamount to demolition. You also have a copy of documents where the council have acknowledged the residential status of some of the lodges. The selling of homes on Tortrees as residential has been an ongoing practice since 2006, a fact that the council have been fully aware of and allowed to continue, and the vast majority of us have unwittingly bought our homes since then. A colleague of mine has recently commented, inaction means sanction. We pay full council tax, and the only thing we benefit from is emergency services. We vote in local and general elections, and even the refuse is now cleared by contractors paid by the new owners, Royal Parks. We each have our own mailboxes on our homes that Royal Mail deliver to, and apart from waste removal, I believe these factors categorise us as being residential. Should this application be refused and the enforcement be brought to action, the local authority would be responsible for housing and benefit payments, as our costs would be greatly increased. We currently pay £395 a month for our site fees, which we would still be liable for. On top of this, we would need to rent or buy another property. There is currently a 1-bedroom 3rd-floor flat on the CBC website, which is £745 a month. There is no way we could afford to pay this. We would lose a huge amount of our children's inheritance, obviously, should we be forced to sell. As you are aware, the majority of homeowners are retired or semi-retired with differing levels of physical ability, which have been worsened by the stress that the enforcement action has brought on us all. One lady has recently suffered a stroke, and a couple of gentlemen have suffered cardiac events, along with most of us suffering sleepless nights. One particularly unfortunate and thoughtless event was where a young lady who has cerebral palsy, and is actually here tonight, and cannot read or write, was delivered the enforcement notice personally addressed to her. The council were fully aware of this condition, and out of compassion could have addressed it to her parents as guardians. We support and are part of the local community and economy by shopping in Herne and Christchurch, and many of us are members of local clubs and attend the Regent Theatre in Christchurch. In conclusion, we are not asking to change anything structural on the park, simply to be granted residential status so we can live here legally. I hope the committee will seriously consider this before making a final decision on the future.
Thank you very much. Well spoken. Thank you. I'd now like to call Mrs. Winter. Could you pop your microphone on, please? Thank you.
My name is Christine Winter, and I'm a member of the Tortrees Homeowners Association Committee. Madam Deputy Chairman and Councillors, ladies and gentlemen, on behalf of Tortrees homeowners, we would like to draw your attention to some very serious issues facing us. We were missold our park homes and told the park has a 12-month full use licence, offered a 99-year lease, and told council tax is payable. Council tax is not payable on holiday park homes. The park owner could truthfully state in his conditions of sale that Band-Aid council tax is payable. This gave credibility to any representation that the homes were able to be used as permanent principal residences, thereby misleading purchasers. The homeowners were advised that they were to be charged council tax in December 2011. The valuation officer brought 67 park home dwellings into the council tax list in May 2012, and the rateable value of the park was significantly reduced accordingly. The homeowners were added to the council tax list on the basis that the homes are privately owned, with 12 months occupancy, and from a council tax viewpoint, sole or main residence had been deemed on the site. Did this change mean the park had residential status as opposed to holiday park status, or were we just left in limbo? Normally, holiday parks charge holiday home owners business/domestic rates and VAT on pitch fees. Residential parks charge council tax but do not charge VAT on pitch fees. We are paying council tax as well as paying VAT on our pitch fees. The VAT office and the council say we should not be paying both taxes, but neither is willing to change this situation. How is it CBC could charge council tax to homeowners when they know such an occupation to be illegal? Why was a breach of planning enforcement order not pursued in 2011-12? The council has consistently benefited financially from what they describe as an illegal act. A precedent has recently been set as the owners of 5 homes have been given immunity from the enforcement orders, and all have been given certificates of lawfulness and residential status because their homes have been lived in for more than 10 years. So it is possible to override Natural England's objections to permanent residence when it's expedient to do so. If we have to move out and leave our homes empty because we cannot sell them at a reasonable price, we will still have to pay all the outgoings on our park homes as well as on our new accommodation, thus doubling our financial outgoings overnight. In their report, the planners actually describe the park as unsustainable, isolated, unplanned settlement, which is a ridiculous statement because the park is located close to snow tracks, is alongside privately owned homes, and is opposite a local farm touring caravan site on the very busy Matcham's Lane, so hardly isolated. Natural England, shall I continue or stop?
I'm afraid I have to stop you there.
That's it.
Thank you very much for giving us your views. I'm now going to ask Councillor Hilliard to come to the table and read out an email that has been sent by your local ward councillor, Councillor Spittle. She's unable to be here tonight, would normally be on the committee, but did want us all to hear her views.
Thank you, Chairman. So these are words of Councillor Mrs. Spittle. Dear Madam Chairman and committee members, I apologise for not being able to attend tonight's meeting due to an important family commitment in London, and would be grateful if you could kindly read out the comments on my email at the appropriate time. Firstly, may I say that these 2 planning applications are 2 of the most difficult to determine I have known during the 18 years I've been a councillor. And this affects so many residents of Trees Park, and this has implications regarding other sites near similar Dorset heathland. As ward councillor, I have visited the site and have been told that a number of these homes have been purchased through misunderstanding in respect of the residency regulations. I also understand that the ground rents, service charges, have been considerably increased during their ownership, leaving them little opportunity to make provision to purchase another property. I'm aware that all the officers dealing with these applications have spent incredible amount of time researching the situation, liaising with residents and this council's housing department to keep them up to date and aware of the possibilities that could arise should these applications be refused. I thank the officers for their time and ask that this relationship be continued to assist and support the residents, many of whom are elderly, suffering, or are carers of disabled relative or child. These properties have been their homes for many years, and as mentioned in the report, create a supportive community in an area not provided with public transport. I agree with the comments expressed by Herne Parish Council in the report. However, in view of the financial implications to this council, inadequate housing availability both nationally and locally, and the emotional difficulties in rehousing the residents, should the committee be minded to refuse the applications, would the members please consider my following recommendation after consulting with the solicitor? That negotiations immediately commence to allow these residents over a certain age, or those with a disability themselves, or a member of their immediate family residing in the mobile home, on an agreed date, be allowed to remain residing at their property either, number 1, for the agreed time, or 2, for the rest of their lives, or 3, until they decide planning restraints and must conform to the planning conditions of tonight 8/07/011, granted 13/4/2007. Consequently, the properties be accepted as holiday homes and not their permanent home. Should this condition be accepted by the council, all appeals lodged with the inspectorate be withdrawn. Thank you for reading this email, which I trust be taken into account by members when coming to a decision. Thank you.
Thank you very much, Councillor Hilliard. We're now going to go back to the officers and allow them to respond to some of the many comments that we've heard in the public speaking.
we start with the issue in respect of the confusion relating to the council tax, the fact that council tax is charged on the premises. That is a separate piece of legislation, and it's an issue that I've dealt with in numerous occasions over the years, when one arm of the council seems to be doing one thing and another arm of the council seems to be doing something else, and they don't talk to each other. That is quite often true because we use different legislation. The council tax legislation looks to obtain council tax payments from any residential property, whether it is lawful or not from a planning point of view. And it is quite often used as an argument when we're considering certificates of lawful development as to when a property first became a residential use. And the lady did mention that we have granted 5 certificates of lawful use on the site where local residents could justify and could evidence that they had occupied, or those units had been occupied for more than 10 years, and therefore they're immune from enforcement action. It doesn't mean to say that we override Natural England's objection. It's again, it's part of the complexities of this site. It is, again, it's a lawful use of the site. It's not the grant of a planning permission, so it doesn't override Natural England's objection. It means that we can't take action because they're immune because of the length of time they've been occupied. So it's trying to get everybody's head round the fact that we are dealing with a complex site with a complex set of legislative changes that apply to it. The council tax legislation is one matter, planning situation is another matter, and it is not unusual that we claim or we charge council tax on sites that do not have lawful planning permission. But just because we charge the valuation office have determined, who again are separate from this council, the valuation office is part of the Inland Revenue, that they determined that the site should be, those units should be charged council tax, doesn't mean to say that they then become dwellings from the point of planning law. You still have to go through the process of proving that you're immune from action under planning legislation, and that is the process that 5 residents have been able to do. And our argument is, and that's why we serve the enforcement notices, that there are no other units on the site that can claim that exemption. So I hope that clears that up. It's probably just made it more confusing, but it is where we're at. We've got different layers of legislation that can act against each other. The other issue was addressed about the fact that it is very unfortunate that a number of you in this room appear to have been missold your properties. We do, as officers, we are sympathetic to that situation, and we do understand the amount of headache and heartache that this process must be causing you all. It's not anything that we would wish on anybody, but we have a duty as the planning authority to enforce planning legislation and planning law, and by condoning mis-selling, that could be repeated on more than one occasion. It could be repeated elsewhere. We understand that there are other actions going on and other considerations, but we're looking at the planning merits of this case. We know about the emotional issues, and the council will be as supportive as it can be. Items have been taken through full council here to support residents as much as possible. Parish council have asked us to be as considerate as possible. The local councillor here has, and that is something that we will continue to work with various external agencies to ensure that the care that we give is as great as we can be. I know you probably don't appreciate today that we seem to be very caring, but we are trying to be. We are basically in a legal situation here, and our legal advice is that we cannot grant these consents tonight. The situation, as has already been mentioned by Mr. Chope, is at appeal, and there are a substantial number of appeals outstanding. And yes, the planning inspectorate seems to be struggling to work out how to carry this set of appeals forward. But nothing that happens tonight will take away your rights to appeal. you have the right to appeal these applications. They can be added to the appeals that are ongoing, so you will still be able to argue your case at appeal. We do not wish to do anything that disadvantages you in that respect this evening, so I hope that makes that clear.
Thank you very much. We're now going to go into questions. Any members have a question? Shall I lead on the questions? My question relates to the comments made regarding if we grant this, it removes the original planning consent. Would that then mean that potentially we would be granting permission to build brick buildings?
No, it wouldn't be that you'd be granting consent to build brick buildings, because we're looking at the use of the land as a caravan site. Caravans are structures, not buildings, and there are a number of appeal cases, particularly in East Dorset I've dealt with in the past, where planning permission is not necessarily granted automatically to replace a temporary structure with a permanent dwelling.
So following on from that, the comment that was made by one of the speakers that in order to remove the homes you would have to basically demolish them, are they then still caravans?
For the purposes of planning legislation and under the Caravan Sites Act, it defines what a caravan is, and they can be quite substantial structures, but they're not buildings. Again, this is where you get the niceties of planning law. The caravan is 60 feet by 20 feet by 10 feet high. There's the sort of criteria of the scale of what is defined as a caravan. It's probably a metric somewhere, but that's the figure I've got in the back of my head from many years ago. And should be capable of being removed from the site in either one piece or two if they're units that are joined together. That's the definition effectively of a mobile home structure. A number of these properties, as you can see from the photographs, have got brick skirts, have got patios. They all properly require planning permission. They are not authorised development, but there's enough issue here with the use of the site, let alone going down and looking at all the individual paraphernalia, which is why the enforcement notice looks at a lot of that, because most of the things I see in these photographs probably require consent in their own right.
So the issue effectively is the development of residential properties within the Greenbelt and close to the heathland.
Yes, it's more to the use of the site rather than what buildings mean.
Thank you, made that much clearer. Do I have any other questions? Councillor Jones?
Through you, could I ask the officers, when we hear that the planning enforcement officer was involved with the Stour Valley Partnership, is that not connected with planning, or does she work completely independent of this department?
Yes, thank you. The issue is we don't have any record of that conversation. We don't know what the question was that was asked, so we can't take that into account. The council has served enforcement notices on what we are told are sound grounds. We don't take serving notices lightly, particularly on this scale, as I'm sure you will all understand. So we don't know what was said. We don't know what question was asked at that time. So I'm afraid we really can't comment on that any further.
Councillor Bath.
Thank you. One of the speakers, I think it was the agent, mentioned a case, I wrote down Arrowcroft case, where an authority did go against Natural England, and I wonder whether you have any information on that or any comment on that, because that seemed to be something which was very similar to what we're looking at today.
Through the chair, the council has taken external expert advice on this issue, the external advice has been provided by a counsel who is very experienced as regards this particular site and the issues that are involved. One of the matters that council had regard to was the Arrowcroft decision. In the light of the Arrowcroft decision, it is his considered view, which I concur with, in fact, that it would be inappropriate for this application to be dealt with under Section 73. No, it's a Section 73. It's a Section 73 application. Sorry, my apologies for being the infelicity briefly of my language.
Could you be quiet from gallery? Thank you. Councillor Jones.
Through you, Chair, could I just ask, obviously this is a topic where you can argue legally we're bound to do this, but morally, can we not take other actions? Expand on this. We did have a case in the borough, I think on Dudmore Road, where there was, not to this extent, but certificates of individual lawfulness were given to the people living there, and at least the council showed humanity, because we're dealing with people.
We appreciate that. The situation is that where a certificate of lawful use could be granted, we've granted them on the site. So that matter has been taken into account. So there are 5 properties on the site where the residents have been able to demonstrate those units have been occupied residentially for more than 10 years. So that's rather like the Dudmore situation, where yes, they've been granted. This is a legal interpretation. We have got to enforce planning law. That is the role of the council, to uphold the planning legislation that applies to the site. All the applicants have the right of appeal against the council's decision, and those appeals are being exercised. Those rights are being exercised through the appeal process. We have got national legislation in terms of green belt, and we've got international legislation in terms of the impact on the heathlands. And the gentleman's correct that I think there's a reference to the Allotment appeal, which is just outside Wareham. There are appeals that go either way, and that's the problem with appeals. Until they've sort of gone through the High Court and they're established through law, they don't have so much precedent as appeal decisions. We use them, but they are, when they get through the courts and they get proceed higher and higher through the process, they have a greater weight in our determination. Natural England were aware of that case and continued to formally object to these applications. And on that basis, as I advised you earlier, we do not actually have the right to grant the planning permission if you wish to, on that ground alone, because you have to refer these applications to Natural England for reference to the Secretary of State.
To check, are we not allowed to give an individual certificate to people who have lived less than 10 years, but were led to believe that this was a permanent site? And it seems to me that in this case there are faults on so many people's sides. We, the council, are not innocent in this. And if we have to follow the law in one sense, can we not at least ignore the 10-year ruling, because we've been accepting council tax from these people on the basis of their
As I set out earlier, no, you can't. The planning legislation is one set of legislation. The legislation that relates to the collection of council tax is another. And it's not unusual that one doesn't mesh with the other. The legislation is very clear that you only grant a certificate of immunity from planning law, planning action or enforcement action, if you can prove a 10-year continuous use of the property. If we say, oh, because of the circumstances here, we won't abide by that, how many other times will you have that question asked to you? It is not something that you have the ability lawfully to do. I know that this is a very difficult set of applications for members. This is a very emotive issue, and we understand that. But you have got the opportunity for this situation to be repeated in more than one occasion. And how many times could we come back and say, it is a problem that there has been actions, and I think people have been misled. And we have got a lot of sympathy for that, but that doesn't overcome our responsibility under the planning legislation to make sure we're upholding your own policies, national policy and international policy in respect of this site.
Thank you. Councillor Neil, do you have a question?
I've got one question to the legal chap, if I may. He might not be able to answer this because he's planning, but isn't it not true that council tax was charged on beach huts and holiday homes a lot fairly recently, within a handful of years?
I don't know the particular situation with regard to that, but these are not planning issues. We are only dealing with planning issues at this committee. We can only make a decision based upon planning law. If I can briefly pick up on Councillor Jones's comments, it would be unlawful of this committee to make a decision based upon the considerations that you present before the committee. Her observations concerning this, although very heartfelt and very understood, cannot form any part of the deliberations of this committee in relation to this application.
Did you want to come back on that?
Thank you very much. I was actually just trying to find out whether we could put that part to bed, because we're being blamed because we've claimed council tax, which is not relevant to this application.
Just as briefly was commented earlier, the issue of assessment to council tax is conducted by the valuation agency, which is part of the Inland Revenue. They would be the party to whom those such concerns should be addressed. They are no part of the matters before this committee as a planning committee.
I'm okay with that. I know that.
Thank you. Councillor Gray, do you have a question?
Thank you, Chairman. I must say how beautifully and maintained this looks to me, and I have driven around there myself. I've noticed that there are 70 lodges, so 65 lodges are 5 have gone over the 10 years. Do we know how many more are nearing the 10 years, or is that, do we individually know? Thank you.
The clock stopped with the issuing of the enforcement notices, so it's only those who can claim immunity prior to the service of the notices. And we understand that but I think there's one more application that could be submitted, but there's a resident, I think, is a bit poorly at the moment, so can't put the application in. But we know that it's likely just one more.
I have a further question. It was regarding the final passage that was read out by Councillor Paul Hilliard on behalf of Councillor Spittle, and what officers thought of that. Would you like me to read it out again? The final passage says, that negotiations immediately commence to allow these residents over a certain age or those with a disability themselves or a member of their immediate family residing in the mobile home on an agreed date be allowed to remain residing at the property either for an agreed time or the rest of their lives, or until they decide to sell the mobile home. In the event of these mobile homes being sold, subsequent owners being fully advised of the planning restraints and must conform to the planning condition number 8/07/0111 granted on the 13th of the 4th 2007. Consequently, these properties be accepted as holiday homes and not their permanent homes should this condition be accepted by the council, and all appeals lodged with the inspectorate be withdrawn.
My clear advice to the committee is that we can't accept a resolution in those terms. It would be unlawful. It could not form part of the proper consideration of this application on its merits.
Thank you for that. Do we have any further questions? Then we're going to go into debate. Who would like to start? Councillor Neil?
Okay, yes, no one else has. We've been advised by council tonight that we are stepping on thin ice if we don't refuse this application. It isn't what the majority of the councillors here would like to see, but legally I see there's no alternative but to refuse this application, which may well then give them the opportunity to appeal, and maybe those appeals may well prove different.
Okay. Anybody like to further comment on that? Vice Chairman?
Thank you, Chairman. I think this is probably the most difficult application that I've sat in on as a councillor since I started in 2011, and I think the emotions of this are really compelling, because we look at these beautiful homes and the pride that all of these people have in their homes, and how much time and effort and money they've spent, and how they've ended up in a situation where they've been missold something, believing it to be a permanent home. And I don't believe the fact that they've been charged council tax for this length of time has led them in any other direction than to believe that they are permanent residents. And I think that is incredibly sad and incredibly difficult situation for these residents. I have every empathy with them all. Sadly for us as councillors, we sit here and we have to look at the law and the NPPF and Natural England and all the laws which are written down, which don't seem to take any account of the emotions involved in this situation. And I find it a really, really difficult case to call. I'd love to be able to say, let's just let them have it, because it's my emotions say that. And I think everybody around the table will feel likewise. But our legal officer has told us that we have sought legal advice, and the legality of it all is incredibly complex. And to me, I believe this is the start of a process which will probably run, and it will go to a lot higher level than we are at right here and now. But what we're faced with here is the law in terms of planning policy and all that we've read, and I've read it and looked at it and driven there, and sadly I feel we have to go with the opposite recommendation to refuse it.
Was that a proposal?
Yes, yeah.
Did you formally propose it? Sorry, you did. Sorry, you didn't say you had, so I wasn't aware. Okay, so Councillor Neil has proposed it. Councillor Bath has seconded it. Would you like to?
There was just one thing that I picked up on, and there is this term, exceptional circumstances, and so far that case has not been put to us. And in my mind, there must be a very strong case for exceptional circumstances here. But notwithstanding that, I still go along with our officer's recommendation for refusal.
We have a proposer and a seconder. I think it's very obvious that none of us like the situation that everybody's ended up in here. I think it's fairly obvious that many of us don't agree with it, but there is, or appears to be, no real legal reason why we should go against the officer's decision. It is based on legal advice that the conditions go to the heart of the original planning consent, and to remove them would remove the planning consent. And we would be allowing residential properties in the Greenbelt. There isn't at the moment any exceptional circumstances to allow that, and we're going to go to the vote. So all those in favour of refusal, please show your hands. That's 4 for refusal. All those against refusal, please show your hands. Any abstentions? 1 abstention. Can we have that recorded? And that application is refused. We're now going to go on to the second part of the application, which is for C. We don't intend to redo the presentation. However, if any of the speakers would like to come to the table again and speak again, then you can have another 3 minutes to speak. I'm not sure if anybody wishes to.
In response to, the officer said, in response to this conundrum about the letter of the meeting on the 12th of June and what happened after that, this letter from the Stour Valley and Pool Partnership makes it quite clear that there was this meeting, and after that, after that, officers of the Valuation Office Agency and Christchurch Borough Council's planning enforcement met to discuss the issue. And that meeting then resulted in the letter of the 4th of July, which confirmed that the occupiers can reside on the site for 12 months of the year, and that many of the homes are owned, and that sole or main residence has been deemed on the site. Surely the planning enforcement officer, and the letter from the Stour Valley Partnership confirms that the actual letter of the 4th of July was copied. They're not sure whether the letter was copied to Christchurch Borough Council, but officers were aware of its content. So how come nothing happened in terms of planning enforcement or planning from Christchurch Borough Council following that letter of the 4th of July 2012? The first time the planning enforcement was carried out was, I think, last November. And so what was the planning enforcement officer doing? It seems, what was said, that there are no records of that. Surely there must be some records. It may be that because of this letter from the Stour Valley Partnership that only came out on the 18th of July, that people haven't got access to those records. But I would have hoped that the councillor would be able to see those records, so that they could find out in more detail what was done on the planning enforcement side following the discussion that was held between the meeting of the 12th of June and the letter of the 4th of July 2012.
Mr. Chair, thank you very much indeed for your submission. The difficulty that the planning committee has, and you've already heard me state the legal advice which has been provided to the council by expert counsel, is that we simply cannot deal with this application in the way that it has been presented under section 73. The matters to which you refer may be the matters of some subsequent discussion, but for the purposes of tonight, this planning committee and these applications, the members have received the recommendation for refusal. That is the one that is presented before the committee.
Mrs. Miller, did you want to come back and speak?
I'd just like to say that all the way through this, Ms King's obviously admitted that the council have made a huge amount of mistakes. So going back well over 10 years, as far as the knowing that the mis-selling has been carrying on the park all that time, and allowing most of us to actually buy our homes since that time. So the council have got to admit some culpability in this. And I think that could well come towards the exceptional circumstances that needs to be taken into consideration.
Unfortunately, I think the exceptional circumstances that were mentioned were the planning grounds for exceptional circumstances of building within the green belt, which applied to.
There are houses a lot closer to the green belt than we are.
The exceptional circumstances apply to buildings such as leisure buildings and sporting activities within the green belt. They don't apply to residential, unfortunately.
There is one brief matter that I would mention, that although this does not concern the planning committee, there are avenues that, of course, if people feel aggrieved about the situation, there are rights to pursue matters under maladministration, but they would not, so far as I can see at the moment, concern matters involving the planning committee.
Unfortunately, we haven't got £600,000 worth of taxpayers' money to fight it with.
Do we have anybody further wishing to speak on the second application?
I would just like.
Could you come to the desk, please? Thank you.
Well,
it means we can catch you on the microphone.
Certainly. I was disappointed in the discussion that there was no discussion at all of the Organford case, which possibly could have presented a get out of jail free card to you this evening if you wanted to grant it. I know Councillor Bath, she said Arrowcroft, she meant Organford, and Mr Morehouse responded on the Arrowcroft point, but it's actually the Organford case that showed that there's no material difference. This is a planning inspector's decision to show that there's no material difference between a holiday use or a mixed holiday use and permanent use Now, obviously, in terms of the appeals, this is going to have to be discussed there. And secondly, in terms of the Section 73 Arrowcroft decision, I referenced three contrary case law there, Powergen, Pye, Lawson Builders, which actually allows you to have a wide range of inquiry of planning merits under a Section 73 application. And again, I'm disappointed that wasn't discussed in the debate. Thank you.
Thank you. Are you able to give your opinion on the Organford decision?
As I mentioned in one of my responses, yes, it's a case that has some. Thank you, Mr. Kane. It has some similarities to the situation on the site, but that is a matter that will be dealt with during the appeals process, because it will be claimed in aid by the appellant in respect to the appeals. These applications, because of the nature of the applications, you can't grant a consent that takes away the substance of the original planning permissions. So there are legal reasons why you can't grant those consents tonight. If these were normal planning applications, then that will be a consideration. But again, as I reiterated before, Natural England, who are aware of the Organford case, have continued to object to this application on the grounds of impact on the heathland. They have substantiated that objection. It still stands. It is a significant material consideration this committee has to take into account.
Do I have any further questions from the committee? In that case, we're going to go into debate. I don't know if anybody would like to start. I'm happy to start as chairman. Again, obviously, we're in the same situation with this application. I'm going to say something our planners don't like, which is I don't like it. We're constantly told off for that. I don't like it. It's very emotive, but this is a legal question, and we've been given the advice by council that we cannot grant this application, and I think therefore that I will from the chair propose it that we do not grant this application, or that we refuse it. Vice Chairman?
Yeah, I go along with what I said before. It's really been a very difficult position for us to be in, and I believe that there are things that have been said by the speakers, by our MP and by the agent, that need to be looked into further. But for us here today, we're considering the advice we've been given by the officers and by council, and I'm going to propose second the proposal for refusal.
We have a proposal on the table and a seconder. Does anybody else wish to join the debate? Councillor Jones.
Madam Chairman, I can see that on a technicality, these things are legal. I find it extremely difficult, looking at what has happened, to say that yes, we're upholding the law, but it seems that we have broken the law in the past. We haven't. We've made mistakes, and
Councillor
I would
Jones,
ask for the future.
I don't think we've actually broken the law. I think we've just, the law has been, I don't think we've actually broken the law. I think you'll find that the law isn't applied in the way we wish it was.
I think, Councillor Jones, I think we need to have those comments struck from the record. There's no evidence of this council having broken the law, and certainly there is no evidence of this council having broken the law so far as planning law is concerned. And that is the only matter which this committee can properly consider. And you will know perfectly well from the code of practice that applies so far as your position on this committee that we can only deal with matters of planning law.
Is it possible then for me to abstain, because I might accept that legally the case has been proved, but I do not feel I can put my hand up? I would prefer to abstain. Am I breaking the law in that respect?
No, you are quite entitled lawfully to abstain. Right. You abstained in respect of the previous resolution. There is no objection to you abstaining.
Thank you. Thank you. That's all I need.
Any further speakers? Then we're going to go to the vote. The proposal is to refuse the application for the change of conditions. All those in favour of refusal, please show your hands. That's 4. All those against? There's nobody against. And any abstentions? There is 1 abstention, and I'm guessing Councillor Jones would like that noted. That application is refused. We will now take a couple of minutes break just to give everybody a breather. I'm going to call the meeting back to order in the next minute or so, just so everyone's aware. Just waiting for Councillor Neil to return. We're now going to bring the meeting back into order, and we're going to move on to item 4D, which is Pine Beach Nursing Home. Who's leading on this, please? Thank you.
Thank you, Chairman. The application before you is to demolish an existing building and erect a block of 10 apartments. The existing building is a nursing home, and you can see the shape of the application site there is quite unusual in that you've got a residential property to the southwest here, and there's a footpath that runs along that direction there. Just while we're on the aerial photograph, I'd just like to make clear that the photograph shows a fair amount of tree canopy in this location to the rear of the site, and that tree canopy isn't really in existence anymore, so don't rely on that aerial photograph for consideration of screening, for example. What we have is an existing building very close to the rear boundary with number 55 here. We've got an element that projects in the rearward direction towards that footpath at the rear, and then the site frontage is all laid to hard standing. The building has been vacant for a number of years, and you can see from those photographs that the characteristic is two-storey with pitched roofs with a linked element. There's a number of balconies on the property, but fundamentally it's the existing building is of similar scale in terms of the general height and characteristics to the surrounding residential properties. The committee have previously approved a scheme for 10 flats on this site. Apologies that this may not appear too clear on the screen, but what we have is a dotted red outline of the existing building to be demolished. You've got a purple outline of the previous proposal, and then you'll struggle to see it, I'm afraid, the blue outline of the current scheme. But moving on to the proposed plan, it's a bit clearer with the blue outline. That was a scheme that we previously granted consent for. We've got the red dotted outline again of the existing building, so you can compare the previous consent to the existing building, and then you've got the proposal that's now in front of you. Fundamentally, the built form is very similar to the consented scheme, but you've got a projection closer to Southcliffe Road on this elevation and on this elevation. The red dotted outline, as I say, is the existing built form, and the light blue dotted outline is the consented scheme. So in general terms, the height of the current proposal that's in front of you is similar height. There are some design changes to the roof form in this location, and you've got an additional dormer feature when you're looking at this elevation. Excuse me. The rear elevation of the approved scheme is the top slide there, and then the proposed elevation that's now in front of you is the bottom. What the applicants have sought to do is reconfigure the internal floor arrangements and provide additional floor space with the projection to the Southcliffe Road side. And then in the rear elevation, you can see there's a large number of additional windows being inserted to address the reconfiguration of the internal accommodation. The applicants have sought to address previously stated concerns from officers about overlooking to the properties at the rear from this elevation. As you'll recall from the site plan, this elevation is very close to the site boundary. What the scheme now proposes is a number of windows in the roof that are marked as obscure glazing. These windows here are raised with a sill level of 1.7 metres. That's considered sufficient to limit any overlooking from those windows. So fundamentally in the roof space you've got 1, 2, 3, 4 windows potentially could give rise to overlooking. When you drop down to the first floor level, you've got obscure glazed windows indicated here, and then these windows in aerial projections are facing away from the nearest residential property. On the ground floor, there's no indication that these windows would be obscure glazed, but the common boundary with the adjacent property is marked by a wall that is considered sufficient to provide mutual privacy between the adjacent property and this proposed development. This element on the end, which is the bit that projects into the rear part of the site closer to the footpath, is the same as what has been approved previously by the council. Sorry, just while we're on this screen here, you can see there's an additional projection of balcony being proposed compared to the approved scheme. The basement has, to all intents and purposes, remained the same in terms of the numbers of spaces that it's providing for parking. There's some tweaking to the arrangement of the bin store and access points, things like that, but nothing fundamentally that gives rise to any concerns in terms of parking provision or highway safety matters. The reconfiguration of the floor areas is not significant on the ground floor. When you get to the first floor, this element, if we start with the top end of the site, is fundamentally the same, as you can see, between the two schemes. When you get to the frontage relative to Southcliffe Road, you can see there's been an enlargement of the built form, additional balconies or extended balconies relative to Southcliffe Road, and likewise there's been some configuration of the other units here. On the second floor plan, which is in the roof space, you'll see that the original scheme had, the approved scheme had these roof light windows serving basically passageways, secondary window here serving this unit, and a hallway there. So there's no significant overlooking arising from these windows, and we were able to condition anything that would enable overlooking, so it was obscure glazed. Excuse me. What we have on the current application is these windows coloured purple, and you'll see from the notation that they're 1.7 metres from the floor level. This section indicates a relative height of the person standing in that space served by the roof light, and when you have a sill height of that dimension, it's difficult to sustain an objection in terms of actual overlooking and loss of privacy from those windows. These windows here in the roof slope are not currently identified as being 1.7 metres high or obscure glazed. You can see they are serving the unit that has substantive glazing this direction. So if it was considered that these are an issue, they could be obscure glazed or raised to a height of 1.7 metres. But the applicant, in reconsidering all the glazing on this elevation, has set out their position, which is reported in the agenda item before you. They consider these are overlooking the roof of the adjoining property, and there's no need for them to be obscure glazed. Having regard to all these changes to the fenestration in the rear elevation, the officer conclusion is that it would be difficult to sustain a refusal reason on the basis of actual overlooking from what are quite a lot of new windows in that elevation. But there is still a perception, if you bear with me, I'll flash back to that. The number and general positioning of these windows could give rise to a perception of overlooking, and that's what the officer conclusion has been, and therefore there's a refusal reason relating to perception of overlooking. In terms of the recommendation in front of you, clearly there's no objection in principle to the redevelopment of the site. There has been a consent. The committee have considered a proposal and approved a scheme for 10 flats on this site. What we're looking at is the significance of the difference between the approved scheme and the proposed, and the projection closer to South Cliff Road and the increased bulk and scale of the building on a visually prominent, effectively corner plot, as you can see from the bend in the road, is considered to result in a harm to the character of the area greater than was previously considered with the approved scheme. That harm can't really be mitigated with the reduced area in front of the building by way of any substantive landscaping. So the conclusion officers have come to in this instance is that the increased bulk, visual prominence and projection of the proposal in front of you is unacceptable and should be refused. As I say, there's an additional reason for refusal relating to the perception of overlooking, and that is the officer's recommendation for you to consider. Thank you.
Thank you very much. We have 4 speakers on this application. We're going to take the speakers against first. So if I could have Ms. Bradley, please. If you'd like to take a moment to introduce yourself, make sure your microphone is turned on, and then we will start the clock.
I live near the Pine Beach Nursing Home, and I'm speaking on behalf of some of the residents of Southcliffe Road. Last December, this committee approved plans to demolish Pine Beach Nursing Home and build 10 flats with underground parking. At first glance, this appears to be a very similar scheme, and the planning, design and access statements submitted with the application attempts to persuade us that this is only a very minor alteration to the approved plans, a minimal increase in size, but that is simply not true. The statement mentions an enlargement of the building on both the southern and eastern sides. It fails to mention that the balconies on the eastern side have also been increased in depth, and a new balcony has been added above the ramp leading to the basement, nor does it mention the 15 additional windows shown on the plans, many of which will overlook neighbours at the side and rear. The building has been increased in size by 1.6 metres to the south and the east. For those of us who still think in feet and inches, that is 5 foot 3 inches, about my height. I wouldn't call that a minimal increase, and certainly not insignificant. Adding to this the increase in depth of the balconies and their supporting walls, the built structure would project a considerable distance beyond any other building on this side of Southcliffe Road, obscuring the view down to the sea for both residents and visitors coming from the public car park. The houses along this side of Southcliffe Road are varied in design, size, shape and age. Some date back to the 1940s. Many have been modified or extended and some completely rebuilt, but all of them have respected the established 30-foot building line. Not just the houses themselves, but garages, porches and balconies are all at least 30 feet from the boundaries of the pavement. Generous front gardens resulting from this conformity with the building line gives a sense of openness and space which is part of the character of Friarscliffe. In fact, in the Christchurch Character Assessment, one of the main characteristics of the Friarscliffe area is properties generally set back with good-sized front and rear gardens. The proposed building at Pine Beach is considerably larger than the one approved last year. It would be much closer to the boundary on the eastern side and have a much narrower strip of landscaping in front of it, which would be out of character with the area. Friarscliffe is a lovely area. Pine Beach is a very prominent site. The proposed building is too big, too dominant, too intrusive. Please refuse this planning application.
Thank you very much. I now have Mr. Radford speaking.
Thank you very much, Chair, Councillors. I would really just like to reiterate everything Mrs. Bradley's just said, and perhaps start by just giving a really some emphasis on how strongly people feel about this locally. We've spoken to a large number of local residents, and I think by contrast to the previous issue that this committee has been looking at, all of those residents would be completely in support of the planning officer's recommendation to this committee to reject this application. It is, as Mrs. Bradley said, a significant change, and it worries us that this has been, as it were, positioned in something that might be deemed less than a significant change. There's been over 47 properties objecting to this, and if you look at the number of residences locally, that's not insignificant on top of the objections that we had to the original proposal. So I think it's hard to find, and I would challenge you to find anybody locally, from local residents or people who indeed visit this area who would be in favour of this proposal. Why is that? I mean, I think for us, it's, as been said, there are, for me, I think 3 key reasons for this. The first, as has been identified by the planning officer and Mrs. Bradley there, is that it's completely out of character to increase this proposal in the way that it's been put forward with the area. It's just too big. It's, as described, physically dominant in a visually prominent location, and therefore this significant increase, and it is at some, versus the original building, 4.6 metres as described, the depth increase is significant. and that's certainly not in character with the area. It's also the building itself is proposed is we believe too dense, and therefore the extension of that with this significant increase, it will result in a number of additional windows, balconies, all of which will overlook adjacent properties in a very intrusive way, which creates a loss of privacy, which is of great distress to some of the residents here, as you can imagine. And this issue can be going on for some time. Thirdly, I'd just like to add in a point of view that we feel strongly about. Those of you who know this site, I'm sure many of you do. It's on the bend in which this building is proposed is one where a lot of people driving around there will perhaps have an eye on the view actually out to sea rather than looking around the bend. And coming the other way, typically, particularly at this time of the year, there are a large number of children going to the beach. And I'm personally quite concerned that if you extend the building this far, you will create a loss of vision around the corner, and that in itself is dangerous. As indeed, I would urge you to consider the construction of the site and how that might destabilise the area. So we would very strongly ask you to endorse the planning officer's recommendation here and reject this proposal, as it is a significant increase in complete disregard, we believe, and to your previous comments and concerns voiced in this committee on this. Thank you very much for your attention.
That was perfect timing. Thank you very much. We now have one speaker in favour of the application. It's Mr. Bennett, the agent for the applicant.
Thank you, Chairman, members. Yes, my name is Adam Bennett. I'm a planning consultant of Ken Park Planning Consultants, and I do represent the applicant. Okay, so the applicants have worked with officers since this scheme was last before the committee to remedy some of the concerns raised. The council now accept that the viability case put forward by the applicants and has now withdrawn its reason for refusal in respect of no affordable housing. The applicants have also submitted amended elevations, as you've seen, in order to remedy officers' concerns in relation to the impact of the development on neighbour amenity. Officers have now amended the reason for refusal to relate only to harm for a perception of overlooking and no actual harm. The objection is therefore on the presence and number of windows and not their actual impact. Members will be aware that the existing care home currently features large, clear glazed, double casement windows which current at first floor level looking westwards across the garden of 55 Southcliffe Road, and indeed those properties which front onto Rook Hill. Proposals seek to provide smaller, angled or obscure glazed and fixed windows at first floor level, and obscure glazed and fixed roof lights at second floor, with clear glazed or openable lights set at above 1.7 metres in height. It's not reasonable to suggest, therefore, that there will be an acceptable perception of overlooking arising from this scheme. The proposals represent a clear betterment relative to the existing situation. The fact that the earlier scheme had less windows is not relevant. In any event, the previous consent did not condition, as suggested, any windows in the rear elevation being obscure glazed or non-opening. Neither was this proposed by the approved plans. The scheme now before members therefore represents a clear betterment to the amenity of residents compared with the approved scheme. The applicant suggests therefore that the council's reason for refusal on this part is not tenable and should not be upheld. The objection on character grounds is twofold, due to a perception that the scheme now proposed will reduce the opportunity to provide a landscape setting to the site, and also that additional massing arising from the modified roof and depth of the building will result in an unduly prominent building. The current building features frontage laid to hard standing. The proposals seek to provide in its place soft landscaping extending to 7.5 metres in depth. The existing hard standing is uncharacteristic, and in comparison the proposals will deliver a significant improvement to the street scene, more consistent with local character. The applicants do not dispute that the new building is larger and extends closer to the highways than the approved scheme, but the council is not tasked with determining which of the two schemes it prefers, but rather the proposals which are before it and whether they're acceptable. The council has already accepted that the building standing close to the highway is acceptable. Buildings along Southcliffe Road feature various projections and extensions and do not sit a consistent distance from the highway. Logically, at the point of terminus to a road, a larger building can be acceptable in urban design terms and would not prejudice the character of the area in standing slightly forwards of this line. When read along the length of the street scene, the building will not appear unacceptably prominent, and the visual gap providing views towards the sea, albeit you do not have a right to a view, will not be lost. The applicants ask, therefore, that members resolve to approve this application, subject to the receipt of a signed UU for the heat and mitigation payment. Thank you.
Thank you very much. We now have the ward councillor, Councillor Paul Hilliard, who's requested to come and speak.
Thank you, Chairman. Members, the report recommendation is to refuse the significant application, which has had 47 letters of rejection from residents. The main points are about over-development of the site, density of development, inappropriate design and impact on street scene, and overlooking and loss of privacy. Public interest is high in this application due to the plot size and its prominent position on the cliff top. Along with many resident concerns, the officer has identified in his report, number one, bulk, scale, mass, combined with the projection forward of the established line and right up to the boundaries, make it out of character of the area. Number two, the perceived overlooking. Now, to residents, this is actual overlooking. They live in these houses, so there is a loss of privacy, a detriment to their amenities. This impacts all sides of the property, with the large three windows, which isn't really mentioned heavily in the report, and the balconies causing severe overlooking. And again, the report doesn't really go into detail that number 15 Rook Hill Road behind the property was in construction and it's only just been completed now. So they are really going to have significant overlooking and loss of privacy. And number three, the site is close to a triple SI and the applicants have failed to consider the building impact to the area. The applicant's design and access statement acknowledges an extent permission for 10 properties only granted in December 2016. And they say this is now not economically viable. It makes us wonder why a credible developer would put forward such a business case. The statement also fails to mention that a previous initial application was withdrawn in August 2016. The agent just mentioned that he's been speaking with the planning officers for some time and has addressed all objections, but looking at the report, this is clearly not true because the officer is saying refuse this application. There's still significant overlooking. As I said, it's the rear windows in particular. There's a lot more rear windows. See, again, the council does not accept that the building forward of a building line is acceptable. So these are key aspects which the applicant's design and access statement really does not hold true. If the development which is accepted from December 2016 is not financially viable, and if the applicant is sincerely life-caring, then residents would be grateful if the applicant would confirm in writing that they could release the permission granted in December 16, relieving their neighbours of stress and anxieties. We would urge members of this committee to follow the robust grounds for refusal provided by the officer and vote to refuse this application. Thank you.
Thank you, Councillor Hilliard. We're now going to go to questions. Would any of you like to start off with a question? Vice Chairman.
Thank you, Chairman. I've got a couple of questions about the development in Rook Hill Road that's now built and the application in respect of the new build there. Have we taken account of the proximity of this proposed application to the development that's happened in Rook Hill Road?
Through you, Chairman. Apologies, first of all, I didn't run through all the slides, but if we address that particular issue, starting with the aerial photograph I referred to at the outset, this is the property in question, in Rook Hill Road. That property has since been demolished. As I mentioned at the outset, this tree canopy on the aerial photograph is somewhat misleading in that there is very little intervening screening. So this property at Rook Hill has been redeveloped following a planning consent, and if you bear with me while I scroll forward near the end of the presentation, I'll show you what it now looks like. This top left shot is the new building that's been erected at Rook Hill. You'll see there's very little intervening screening, so that was the point I was trying to get across in terms of the canopies. These bottom shots are actually taken from that new property. It wasn't quite completed when I went there, but this is the first floor balcony in this location here between the gable and the other part of the elevation. So you can see, if you're stood on the balcony of that new property, this is the existing building that would be demolished, and these windows are in the same sort of position relative to the boundary that the current proposal has. It's not considered that a privacy issue could be sustained with regard to that rear elevation with respect of this Rook Hill property. I believe the fundamental concern of the occupier of this property is what happens in the rear elevation of the element that is to be built in this location here. Just before we leave this slide, that's the side elevation of the Rook Hill property when viewed from other properties in Southcliffe Road. So you can see that relationship. To the rear of the property, there's a single story structure here which houses a swimming pool, and there is an existing relationship in terms of overlooking from the Southcliffe Road properties to that swimming pool building and to these windows in the side elevation. So if we were to return to the rear elevation that's been approved, this is the element that is closest to the Rook Hill property. As I said, that is identical to what is now before you on the current application, so there is not considered to be any substantive difference in overlooking that could arise to that Rook Hill property when you compare the approved and proposed schemes. As I said before, the windows in this rear elevation are not considered to give rise to any significant overlooking of that Rook Hill property. Apologies, I wasn't able to get through the presentation with all those slides. Thank you.
Thank you. Do we have any further questions? Then we're going to go into debate. I'm going to start off by asking a question or commenting on the fact that the only reason this has actually come to committee is because of Councillor Dedman's interest in the property, and actually this would otherwise have been dealt with under delegated powers by the officers. And as such, I'm going to hand over to the ward councillor, who is vice chairman.
Thank you, Chairman. I think, as you say, this has come to us because of the chairman's interest, but also I think the number of letters that we've received as well would have brought it to committee. No? Oh, okay, sorry, I'm wrong there. But anyway, there is an awful lot of residents who are very concerned about this, and I can absolutely understand why. It's a very prominent building structure that is past its sell-by date. It looks a bit tatty now and rather sad. So it would be nice to have something there that is a benefit to our beautiful ward. However, I believe this is pushing it far too far to make it increase in bulk and mass and bring the building line further forward and actually dominate the area more so than it needs to. I think the existing proposal as stands should stand, and we should go along with the officer recommendation for refusal. So I totally support that recommendation and would like to propose it.
We have a proposal. Councillor Jones?
Proposal to refuse. I totally agree that it is a case of bulk, mass, scale. It will ruin one part of an important area of the Friars Cliff region, and I don't think it's acceptable. So I would second.
Thank you. We have a proposal and a seconder on the table. I will take it to the vote. All those in favour of refusal of this application, please show your hands. That is unanimous. The application is refused. We're now going to move on to item 4E, which is land east of Phase 8 Hoban Estate. Who's leading on this, please?
I am. This application before you is land to the east of Phase 8, which is the current phase under construction at Hoban Farm Estate. A development that, as members will be aware, has been under construction for many a year in various phases. It is, for those of you who don't know it, sorry, get the mouse. This is the A35 Lyndhurst Road, Rowshot Hill. Last committee members will recall determining a planning application for outline residential application on the allocation site at Rowshot, which is immediately to the north of the road here. And these are the phases that are under construction on the site at the moment. It is an outline application for up to 38 dwellings, and the only matter before you this evening is an application for a point of access, which is here, on Hawthorne Drive. There are illustrative plans submitted with the application, but they are purely for illustrative purposes only, effectively to try and ensure that your offices are content that a scheme of up to 38 could work on this site. The land in question at the moment is unused. It's not occupied by any buildings or structures. It is very open. These photographs here are taken along the A35 looking into the site. You can see the development that's going on the existing phase at the moment. There is an existing bridleway that skirts along part of the site, and that's the only form of public access into the land in question. This shows the edge of the development with the line of pine trees along its boundary. The site itself is open paddock, effectively. It's sort of scrubland now. It's got lots of brambles on it and various things regenerating. You also have got a strong line of trees in this location, which are, as I say, the grounds of Verno House, This part of the site just within the Burno Lane conservation area. And the photographs here just give you a sample of the nature of the area. So if we go back to the original plan, you are looking tonight at an application for up to 38 dwellings with affordable housing, and the applicant has confirmed this afternoon that that will be 40% affordable housing in line with your policy, and that will be established via a 106 legal agreement. There is also a requirement for contribution to improve the footway, cycleway on this portion of the site out onto the A35. There's a financial contribution to ensure that works can be done. There are a number of concerns that have been submitted in respect to this application from local residents. In fact, in respect of that, it's considered to be a piece of open space, that they don't know what the form of the development could be. You know, the tenure could be inappropriate, the size and scale and height of the buildings could be inappropriate. At the moment, you're only considering an outline application. All matters are reserved other than the point of access, and the Highway Authority have no objection to the point of access. So in terms of scale, layout, etc., you are looking at application for the 38 units. You'll also note in the report that there is a proposal to have more than 2 hectares of the site actually designated as formal public open space. At the moment, the site has an allocation in the old Christchurch Borough Christchurch local plan for open space, but that designation has never actually formally been carried through, so it's not formally designated in terms of anybody having designation over it. So we are getting, as part of this application, a significant proportion of the site as open space, so then there will be public access to that. It protects the trees along the eastern boundary with the conservation area, so it is actually, that is a betterment in terms of public access to the site at the moment. There are concerns from the local landowner in particular about the nature of the site and the scale of the site, and whether proper mitigation for impact on the Dorset Heaths has been considered as part of this application. Now, those members that sat around this table more than once will know that if an application, if the scale of the development proposed is sufficient to have a significant impact on heathland, then we will require an on-site SANG, suitable alternative natural green space. Your core strategy looks at schemes of about 50 to require a SANG, and your SIL requirements are for schemes of about 40 may require a SANG on site. There's been a considerable amount of discussion with Natural England colleagues over the years on this scheme to ensure that the mitigation put forward from this application meets both national policy, international policy, because habitats regulations is an international piece of legislation, but it's enshrined in our British law. It meets the requirements of your core strategy in terms of it's not a scheme that does generate the need for a SANG. It doesn't generate the need for a SANG from your SIL regulations, nor from the South East Dorset wide special supplementary planning document on heathlands, which is operated across parts of Bournemouth, Purbeck, Christchurch and East Dorset, which sets out very clearly what sort of schemes generate what type of mitigation requirements. And you have, as set out in your agenda, a statement from Natural England to say that this scheme does not require an on-site SANG. The mitigation proposed by the applicant is in line with your policy in terms of a SIL contribution, Community Infrastructure Levy contribution. That money will then be put towards the mitigation of harm of additional residential development within the borough. And on your update sheet, you will see that your countryside team have set out 3 schemes that could be used to mitigate the impact of the development in the borough. And one of those schemes is a skate park at Waterman's Park. And skate parks and BMX parks are actually one of the listed types of mitigation that's actually set out in the SPD. Mitigation for the heathland doesn't necessarily have to mean a SANG. It can be other projects within an urban area to deflect the use of the heathland for recreational purposes and get users off the heaths and into other facilities within the urban areas. And the other thing to bear in mind is that the more than 2 hectares of open space that's proposed as part of this scheme is a significant portion of land, which again will help with the mitigation. It will reflect dog walkers from the heathland. They will be able to use this formal area of open space. And that could include existing residents in the area as well as residents proposed by the development. So in light of the advice from Natural England, we feel that this scheme is wholly policy compliant. We recognise the concerns of local interested parties, but we've tested this carefully and are consider that this is a policy compliant scheme. The applicants proposed mitigation by way of SIL, which is in accordance with your policy, does carry out that mitigation, and then we have to make sure that we spend that money accordingly and actually carry out that mitigation. And that is something that our countryside team have indicated there are projects that could be suitable for that. And of course they will have to be signed off by Natural England to ensure that they are projects that are suitable to actually carry out, to effect that mitigation that is required. Sorry, I'm passing notes to each other here. It's getting drafty, so we're going to close the windows. So, excuse me, yeah, my toes are cold today. So, in light of the proposal before you this evening, it is purely an outline application, and I know some members feel uncomfortable in dealing with outline applications, but it is one that is, if we have looked at it, we have had a lot of information that comes in with the application to support the number of units the applicant is proposing, but all members are asked to consider tonight is a scheme for up to 38 with 40% affordable housing, requiring a contribution to ensure that the footway, cycleway onto Lyndhurst Road is acceptable and that the access is onto Moorpower Drive. There have also been concerns about putting a new access onto Lyndhurst Road. The Highway Authority would be very keen not to do that. So there is no proposal to put an vehicular access onto Lyndhurst Road. That does not meet highway safety requirements. Thank you.
Thank you. We have 4 speakers on this. We're going to take the speakers against first. First speaker is Mrs. Bond. If you'd like to come to the table, introduce yourself, and then we'll start the clock. You have 3 minutes.
Good evening, Madam Chairman, Committee, Councillors, ladies and gentlemen. My name's Mary Bond. I'm one of the residents who already live on the Hoban farm estate, and I'm speaking on behalf of a number of residents who have lodged their objections with you, yourselves, and with the agent who proposed this. We bought our house on the development 7 years ago and chose a house with a position close to the land designated as open space. Our friends and neighbours chose theirs with the same important consideration. Mr. Cox was looking at properties in this area and found a plot which he liked in what is now Daisy Close. He saw that his proposed new garden backed onto open space. He decided not to rely on information from the builder, but went to Christchurch Council and spoke to Mrs. Kim Bowditch. She reassured him and wrote to him on the 15th of October 2015. I have that in front of me, I'll read the paragraph. Whilst it is not possible to offer categorical assurance the land will never be developed, the plans show that the land adjoining the final phases of development were identified as open space on the approved plans, and it would be expected that they would be retained as such following the completion of development. Mr. Cox went ahead and bought his property. Reading the documents that came with the online outline application, The noise assessment found the levels from the A35 traffic to be unacceptable, particularly for the proposed units 18 to 38. The acoustic barrier erected on the boundary of Phase 8 on the A35 will only help, but not for people opening their windows. Policy LN3 states that affordable housing should be dispersed across the site in small groups, rendering it impossible to distinguish between tenures. This is not possible on a development of this size where there are only 38 proposed units. Why would a cycle path be needed? There are existing cycle paths. If one was needed, open up Hoban Lane. The large amount of traffic along Cornflower Drive and Saffron Drive, including parked cars and noise, are of great concern to all residents. We do not need a children's play area. The equipment provided in other areas of the development is not maintained, so it is not used. If any development is to proceed, there needs to be a buffer strip outside the boundaries of properties which back onto the green space. This should consist of large shrubs to form a hedge, or preferably change the position of the proposed road to go along the boundaries of Daisy Close, etc. The biodiversity plan states that there are 7 species of bat on the site or commuting across it. These bats are regularly seen in the gardens of Daisy Close, which backs onto the development. Many bird species to be seen here include green woodpeckers and greater spotted woodpeckers. Rabbits are numerous and enjoyed by at least one fox, which hunts here regularly. We hear tawny owls communicating at night, probably enjoying any dormice and voles that may be at present. Please do not grant this application.
Thank you very much. We now have Mr. George Merritt. Not going to speak. Okay. We now have 2 speakers in favour of the application. First is Mrs. Jackson, who is the planning consultant.
Can I just correct you? I'm not the planning consultant for this application. I am a planning consultant. Okay.
A planning consultant.
Thank you, Chairman. I act for the Merrick Estate, and the estate supports the delivery of new housing in Christchurch. However, the estate does believe in considering this application, the committee should be aware that there is a legal matter important to all housing applications in Christchurch that goes beyond normal planning considerations, and this is the habitats regulations. For smaller sites of less than 40 units, as this is their application, the payment of community infrastructure levy is a method for securing mitigation in the form of heathland implementation projects, or HIPs. What this means is that the sites of less than 40 dwellings do not have to secure their own mitigation. Rather, what they do is rely upon mitigation across the borough, provided that that mitigation is effective and otherwise compliant with the supplementary planning document. There are, however, a number of practical problems with relying with this approach. First, the mitigation provided or procured by Christchurch needs to be effective with the SPD and compliant with the SPD. Secondly, there needs to be effective SPDs in place before the development is occupied. And your update sheet refers to 3 projects, 2 of which are not yet secured, and the third of which involves land in the control of the estate, and so it is not certain. Thirdly, crucially, the funding and management of the maintenance of the mitigation project needs to be secured for 80 years. Consequently, committee members, you must be certain that effective SPD compliant mitigation must be delivered for in perpetuity, that is 80 years, so that you can be satisfied that the proposed development will have no adverse effect on the Dorset Heath. You're certainly not at that point from the projects on your update sheet, and your officer has pointed out that you cannot rely on the open space yet because the layout is not fixed and it is not necessarily secured for 80 years. I've suggested to officers that need to take a careful approach in recommending approval, and I have suggested the use of a condition to ensure that development deals effectively and promptly compliant mitigation that is compliant with the SPD as advised by Natural England in the report. The development should not begin until it is certain that the mitigation is both in place and funded for that in perpetuity period. My suggestion for this condition has not been supported by officers. Yet in the case of Roshot, 45 acres of sang were needed to be in place before a single dwelling was occupied.
I have been in contact with Hoban Developments about the potential use of the estate-owned woodland at Cranemore as mitigation. Natural England support the use of Cranemore in this way. Cranemore would satisfy the mitigation required. I have had discussions with your officers on how to bring this forward, who are in principle supportive of that project. But Cranemore, or for that matter any other mitigation, needs to be certain before you can reach a point of making a decision on this application. It means it needs to be tied to any planning consent permission before you resolve to grant consent. I want to stress the importance of this issue. A recent planning appeal in Poole for just a single additional bedroom was dismissed on the basis that the inspector needed to be satisfied beyond reasonable doubt that development would not adversely affect the Dorset Heath. This severe legal test is because the status of law in relation to the protection of the heath, as the officer has said, goes beyond normal planning law. It is international law. The habitat regulations are in fact a super law. The Hoban proposal could create 150 bedrooms. Can you be sure that you have met the tough legal test in the habitat regulations?
I'm going to have to stop you there. You have had just over 3 minutes, but
Sorry.
we actually forgot to start the buzzer.
Okay.
My apologies. We now have Mr. Johnson speaking, who is the agent for the applicant.
Thank you, Chairman. The application proposals before you today are the culmination of over 5 years of joint working with your officers and statutory consultees and engagement with the local community. The site was identified by the Council as suitable for housing in 2012 and forms part of the housing land supply relied upon for the now adopted local plan. The applicant has worked collaboratively with your officers, Natural England, Dorset Wildlife Trust, the county's Natural Environment Team, County Highways and many, many more to ensure the application before you this evening is soundly based and merits the recommendation for approval tabled. The applicant has listened and responded positively to the feedback and suggestions made throughout the design process. This includes setting aside over half the site, over 2 hectares, for public open space use, with woodland paths providing connections to the existing and emerging urban areas surrounding the site. Whilst the layout, appearance, scale and landscaping of these proposals are all matters for consideration and indeed consultation at subsequent reserved matter stages, care and attention has been put into assessing and articulating the right vision for this site. Hoban Developments are a local home builder who pride themselves on the quality of place they create and importantly the legacy they leave behind. Good quality design, detailing and landscaping is embedded in their schemes. They have worked hard with your officers and all concerned to deliver a final phase that respects, integrates and enhances the Hoban estate. In closing, I would like to thank your officers for their time, hard work and a collaborative approach to bringing these proposals to fruition. I would also respectfully and wholeheartedly endorse their recommendation for approval, subject to the conditions and the Section 106 obligations outlined herein. Thank you very much.
Thank you. We also have the ward councillor who'd like to come and speak, Councillor Trish Jameson.
Chairman, members, thank you for allowing me to come and talk to you on behalf of residents West Highcliffe on this outline application. This has been brought to you by a number of because of the number of objections as well as petition against it. I also have grave concerns over this application, and I realise that you are only considering access details for up to 38 dwellings, which include affordable housing, public open space and landscaping with associated access. Members, one of the reasons given for the officers recommending granting is that the new development would not significantly be harmful to the residential amenities of the nearby dwellings. I totally disagree with this statement. The outline plans show how the new dwellings will back onto some of the older dwellings in Daisy Close, with the road running at the front of them. This would have a significant impact on the neighbouring conservation area and a significant increase in traffic running through the proposed 5.5 metre wide carriageway. The site is at present public open space, and as Mrs. Barnes said, the resident in Daisy Close, when purchasing his property, specifically asked the question about open space, and he was told in the letter by an officer that there were no plans for further development. This site forms habitat for fauna and flora, and also forms a buffer between dwellings and the very, very busy A35 Rochdale Hill. Members, I feel very uncomfortable over this outline application. I feel there is too little indication of how the site will be developed should this outline application be granted. I'm also uncomfortable with the information about the financial benefits. I feel that there will be little benefit for the local residents, that financial benefit takes preference over other benefits for our residents, such as open space. Members, I ask you to consider this carefully and to vote against the recommendation made by your officers, and ask the developers to rethink where the main road is going to go through the site and to consider residents that are living there. Thank you.
Thank you very much. I believe the officers want to come back on a few things that were raised during the speakers.
Working backwards from Councillor Jameson's comments, this is an outline application only, so there is no position of the dwellings or the roads or the landscape or anything is fixed. So that will be for matters, for reserved matters for consideration by the council. But the fact that development could occur in proximity to existing dwellings is not a reason for refusal. The relationship between existing dwellings and proposed dwellings will be carefully considered at any reserved matter stage, and it's not unusual for development, or when you're doing it in phases, to have relationships with existing properties. And I think the reference to the letter sent by one of my colleagues to a local resident made it clear we couldn't categorically say that development could not go ahead on this site. The National Planning Policy Framework, which has come in since that correspondence, has changed the emphasis on making the best use of urban land. This site is within the existing urban area and has been identified through the Council Strategic Housing Land Availability Assessment as suitable for residential development. It is making good use of that site. So in terms of the principle, there is no objection in principle from a planning point of view to the development of the site. And the matters such as funding, landscaping, trees, relationship and the mix of affordable housing are all matters that will be dealt with at the reserved matters stage. There will be consultation carried out with local residents in respect of those applications as and when they come in, and we will consider carefully as officers to ensure that the development has the minimal impact on the surrounding area. Another issue that's been raised is the impact on wildlife. Well, the application has been submitted with a significant biodiversity mitigation plan, which has been considered by Dorset Wildlife Trust, Natural England and the County Council's Natural Environmental team, who have signed off the mitigation plan as acceptable to mitigate the harm of the development, the impacts of the development, not the harm of the development, both the impacts of the development on the wildlife affecting the site per se, and also they have assessed it in terms of its impact on the surrounding European protected heathlands, in terms of the mitigation that is proposed, in terms of the financial contribution that will be collected through the SIL payment. So those matters have been looked at have been addressed fully by the applicant in the papers that have been submitted in support of this application. You have no noise objection from anybody. Again, if there are issues with the relationship to the A35 in that location, that will be a reserved matter that we dealt with at a later stage. So we understand the concerns of local residents, and it's always, we've had this debate in this committee more than once, outline applications do leave members feeling a little uncomfortable because you don't know what you're getting. But the applicant is fully entitled to submit an application in this form. We have to consider the application before us. The application is submitted with sufficient supporting information to demonstrate that the scheme can be made to be acceptable in terms of its provision of the access, the relationship to neighbouring properties, the provision of affordable housing in accordance with the council's policy, which is a major consideration in this application. Provision of affordable housing is one of the objectives of the authority, and the site will provide a very much needed assistance in that direction. And we also then go back to Mrs. Jackson's comments about the Heathrow mitigation. The application is making its contribution towards Heathrow mitigation through the provision of the SIL payment, which is what the policies require you to do. What we have to ensure is to make sure we spend that money correctly, and that is something that is for the council to do. We cannot link an application, or every single residential application, to the provision of the mitigation works. The suggested condition that Mrs. Jackson proposed hasn't been applied to any other development in the area. It hasn't been applied to the requirements for mitigation have been in place since 2007. This issue is not, there is no condition required through the special supplementary planning document that applies to protection of the heathlands and the ensuring that mitigation happens. It has not been requested through any other appeals in this borough or East Dorset that I'm aware of. Inspectors have looked at this matter on more than one occasion. We do not consider it necessary here. The schemes that we put forward on the update sheet can be, at least one of them can definitely be delivered in line, provided the Natural England are content with it. And if I can read you part of the Heathland SPD, it basically says that this, I'll go back to the beginning. Since January 2007, local authorities in South East Dorset have been operating a strategy based on delivering a range of measures to mitigate the adverse effects of residential development while bringing forward individual local plans and core strategies. Each of the local authorities now has an up-to-date plan which sets out a consistent policy approach across the wider area. This document, which is SPD, sets out the approach to enabling development through the implementation of measures to avoid likely effects on the Dorset Heathlands and South East Dorset. Strategy is a long-term approach, with the SPD setting out a 5-year rolling programme of measures. And the strategy consists of Heathland infrastructure projects, which we call HIPs, because we like acronyms, and strategic access, management and monitoring, which is to make sure that we can protect the existing Heathland. And the HIPs projects are projects that provide facilities to attract people away from protected Heathland sites. They can be through SANGs, which is suitable alternative natural green spaces, but they can be other projects which are likely to have more bespoke to local areas, and for example may consist of creating linkages between open green spaces, recreational facilities such as BMX tracks or fire access measures. So there are a multitude of methods of mitigating harm which, taken together as a package across the area, do reduce the impact of residential development on those heathlands and mitigate the harm. And also in your report at the end of para 7.3, return to Natural England's advice, it says, in summary, it is Natural England's advice that your authority may take the view that this application for 38 dwellings, given the local context, will be compliant with the adopted local plan and the advice in the Dorset Heathlands Planning Framework SPD. and that it would be not therefore likely to have a significant effect on the nearby designated sites region. Having secured the appropriate avoidance and mitigation measures under the SIL and the 106 mechanisms for SAM, Strategic Access Management and Monitoring, Natural England would then have no objection to the authority approving the application set out in previous correspondence. And that's the advice to this council from the government's advisor on natural environmental matters, and the application does deliver that SIL payment.
I'm sorry, could you be
also the
quiet,
SAM
please?
payment.
We're trying to listen.
So the application is policy compliant and is not objected to by Natural England, and therefore we do recommend it to you for approval.
Thank you. Do I have any questions from members? Councillor Grace.
Is the only access road onto Cornflower Drive, or is there any other access into the properties if they're going to go ahead? At some stage, I know it's only outlined, but I'm just wondering if that's the only access.
That's the access applied for.
Yeah. And the other thing is, I know, actually, I don't know if I can really speak about this, but the indication only of these properties backing on to the other properties, I know it's only a plan, an indication plan. Could, if this was to go ahead, could they not be moved to the other side of the road, or is that not allowed? You know, when this fake road that we've got here that you can see, so that they don't back on to the properties already there.
That would be a matter for the Reserved Matters application, and
We
there is
can't
no
do that.
not necessarily any harm of having properties backing onto each other. It's a normal situation. Yeah. We will ensure that there isn't any significant overlooking or loss of amenity to those properties. But unfortunately, you don't get a right to a view unless you actually own the land on which that view is. You know, the application has come in accordance with national policy and the MPPF, and I understand the residents who thought they were buying onto an open field, but it was in the urban area, and there's nothing to say long term that land wouldn't come to open time.
Thank you.
Councillor Bath.
Thanks, Chairman. There's a question about the open space, which seems to have created quite a lot of unrest and upset, because I see here we've got this retained policies of the Borough of Christchurch, policy L9, which is designation of the land at Hoban as open space, and then also we've got the core strategy where the land is allocated as a potential for up to 100 houses. So my question is, why was that retained policy retained if it's been superseded by another policy?
The site's not formally allocated in the core strategy. It is identified in the Strategic Housing Land Availability Assessment, which is one of the supporting documents that supports the core strategy and looks at the provision of housing supply to meet the targets within the core strategy. It's a site that is identified to have potential. The existing policy in respect of the open space has never formally gone through the process of actually designating this as open space. Yes, it is questionable why it remained, but the application as submitted to us and the plans that's submitted with the application show that 50% of this site is effectively being offered as open space as part of the proposal. So that will actually secure a significant amount of open space for residents to use in perpetuity that isn't there at the moment.
Back on the strategic housing land assessment, was that then part of the consultation through the core strategy so that members of the public could make representations about that being in the SLA, that could future possibility that it would come up for development?
Not as such. It's one of the evidence studies. It's there. It's buried in the evidence studies that support the core strategy. It is a public document, but it's not something that we consult on. We do what's called a core for sites, where you do items in the paper, adverts in the paper, in the press, and we consult local landowners and local developers and agents as part of a national policy of how you carry out a SHLA, to say, have you got land that you would like us to consider suitable for residential development? And again, it's in accordance with the requirements coming out of the MPPF. So it is a mechanism that all local authorities use to assess the development potential within their area, and that information fed into the local plan inquiry and was part of the justification for the fact that we could meet the housing target without involving more green belt land take than we actually had.
Councillor Jones.
Madam Chairman, could I ask the officer, looking at 8.5, I think this links up with Councillor Bath's question. Does this mean that according to the strategic housing assessment, it would be regarded as suitable for up to 100 homes?
It could be, but then we go back to the fact that the site of more than 50 units would require a SAN, suitable alternative natural green space, to be able to support it, to ensure that the mitigation of the impact of the development on local heathland could be satisfactorily dealt with. There is no suitable SAN that could accompany that scheme. I think there have been discussions about it, but to date one hasn't come to fruition. So no, we didn't allocate it for that number, because the impact of that number of units could not be mitigated in a way that we could guarantee through the policy plan.
Could I ask, in the future, could another planning committee turn down an application for the number of possible homes stated here in this outline commission? We're not bound by the 30 whatever.
Sorry, it says up to.
Yeah.
Because as it is an outline application with all matters reserved other than the access, we can't fix the number, because we need to be guaranteed that that development would fit, and that's only at the reserve matters stage. So the reserve matters application couldn't come in for more than 38, and if we feel that the 38 proposing doesn't fit, then you're perfectly entitled to refuse it.
Councillor Neil.
Through Chair, there was some dates mentioned about 2015 and the open space, where the council was requested or asked about the open space, but someone else said that we've been working on this for 5 years. So was it appropriate for the officer or someone to tell the people in Daisy Close that there's no sign of it being used as development land?
Councillor Neil, I don't think that's a relevant planning matter.
Okay, well, I'll move to the next one then. If we grant, or reminded to grant 38 houses on this, and then another 2 houses or 4 houses are added, which would have taken it over the number required to put a saying in, would that picked up at the next stages, or would it be considered as a separate increase?
As I just said to Mrs. Jones, the application is up to 38. So if the reserve matters came in for more than 38, it wouldn't be in accordance with the reserve matters application. It'd have to be a full application. So that matter would have to be considered afresh if it comes to fruition. At the moment, you're being asked to consider an application of up to 38 units that does not generate the need for a SAN.
And one last question, if I may. The top end of the map shows a sort of grey pathway, I take it. Is that part of the cycleway that's going out onto Lymington Road?
The application in your plans pack is the illustrative plan that came in with the application. It doesn't actually form part of the application. So there's nothing fixed. It's vehicular access is what's fixed. If you notice in your recommendation, there is a recommendation that a financial contribution is made to the county council to secure footway, cycleway improvements along the A31, 35 rather. That may include land that's highway land or third party land. So the responsibility of delivering that will be to the highway authority, not to this applicant.
I have a question myself. In comparison to the existing development, 38 houses seems to be quite a lot less dense than what's already being built out. Could you give your opinion on that, please?
Yeah, the form of development, 38 units on that site, could be argued to be an underdevelopment of the site. The site has potential for 100, but that can't be delivered because of the requirements for SANG, which are not achievable at the moment. So we are charged with making best use of urban land. This scheme could probably result in a greater mix of housing types and styles and scales than exist in the estate at the moment, but that is national policy. That is what you are required to encourage developers to do to actually meet your strategic housing market area assessment, which looks at where the need is for different types of house sizes across the borough. So it would be, again, a policy compliant scheme that we would hopefully bring back to you at a reserved matter stage.
And with reference to the condition that Mrs. Jackson was talking about, whilst officers don't agree with adding it as a condition, would they be happy to add it as an informative note so that we were aware that reference had been borne to it?
No, because it doesn't really belong to the application. It belongs to the council to implement their own duty to mitigate, to deliver the mitigation. The applicant is doing what the policy requires, which is to ensure that they make the necessary contributions to mitigation, which they're doing, which is then up to us to ensure we deliver that.
Okay, thank you. Do we have any further questions? In that case, we'll go into debate. Who would like to start? Vice Chairman.
Thank you. It's another complex situation with a lot of emotions running high again, with lots of residents who obviously felt that they were buying properties adjoining open space that was going to remain open space. But I think through the officers' responses, we've had a very clear indication that unfortunately that isn't the case, and there was no guarantee of that, even though they were led to believe possibly by various means that it was going to remain so. Our core strategy that went through various lengthy processes came up with numbers of houses that we need to provide in our area to allow people to be able to live and families to be able to remain in the area. And unfortunately, I can empathise with the feelings of the residents who live close by to what currently is an open space, but the policies that we have support this being developed for housing, and particularly the affordable housing element is very much needed, with our housing list still relatively high for local people who can't afford to purchase their own homes. So for all these reasons, I feel that we should go with the officer's recommendation and approve this application, this outline application, and I'm happy to propose that.
Any of the members wish to second that? In that case, I'm actually going to go ahead and second that proposal for exactly the same reasons. I do believe that this is a development that is less dense. It does include open space. It is outline. We haven't seen the reserved matters, and it will be coming back to us. And I'm happy, therefore, to second the proposal. So the application has been proposed and seconded for approval. All those in favour of approval, please show your hands. 4 in favour. All those against, please show hands. Any abstentions? 1 abstention. That application is approved. Before we go on to... Sorry, excuse me. Before we go on to the next item on the agenda, it is coming extremely close to 9 o'clock. We therefore need to have a proposal from a member to extend this meeting beyond 9 o'clock. Would anybody like to propose that? Vice Chairman.
Yeah, happy to propose that we continue to go through to the next item. Sorry, 2 items.
2 items. Councillor Grace has seconded it. All those in favour to continue? It is unanimous. Then we shall go on to item 4E.
Thank you. This item relates to a proposed development at 9 Freshwater Road. The application in your agenda starts on page 85. The application is for ground and first floor extension, including a first floor balcony, and that follows partial demolition of an existing conservatory, conversion of an existing garage, living accommodation, and creation of additional parking space. The site lies at the head of a cul-de-sac of Freshwater Road on the western side located here, backing on to Eastcliff Way and Seaward Avenue here. I would just say that there was a previous application that was refused in August 2015 for a slightly larger scheme on the site, and I will refer to that as we go through. The slide down here shows the dwelling. Members may be able to pick up that rather behind this tree you can see signs of a balcony sitting on a flat roof above. This is actually the living room to the property. Subsequent to this photo being taken, these tiles were removed from the roof because there was a flood within the there was a leak in the roof. This just shows it from a slightly different angle, and a pick up at the moment there is a there's a garage in this location here. Oh, that's a bit strange. This photo here shows a view from an existing landing window at this part of the existing building, first floor, and it's looking towards Seaward Avenue. This area is within a special character area, just for members' information. Photograph B shows the relationship between the application site, number 9 being here, and number 7, the adjacent property here. And we'll just point out that on this elevation, the existing elevation, there is a window at the first floor level here, but also a window, quite a wide window, serving the garage at this location here. Photograph C is in this location, taken at this location here, and it's proposed that there would be an additional parking space to compensate for the loss of the garage which sits here. And the conservatory at the moment is across the back of the property. These are the existing elevations. So this is the garage window that I referred to that faces number 7 with a first floor window above. That's the south elevation. This floor plan here shows existing landing window, which I will show you a view from that window in a moment. This is the existing landing window, which faces number 32 and 34 from this location. This are the proposed plans. This shows the proposed elevations here to the balcony. So you'll see that this is currently sitting within a false pitch. It will become a larger balcony, so this will be a new area of balcony here and an extended area of balcony here. Just to advise members, the red dotted line shows the extent of a previous scheme. Members will note that it has been pulled back here and that the roof that was previously hit is now gabled to reduce the impact. There was also a proposal to put an attached garage in this location here, which would now become a parking space. Again, the red dotted lines show the profile in elevation of that existing garage. This again just shows the opposite view to this, showing the extent of the extension at that time, and there is the garage in that location there. Actually, if I could just go back, I think this is the view from that landing window to the properties in Seawood Avenue. This is the current view. This set of plans here shows the areas of change from the previously refused scheme to the current. So here you are seeing the side elevation of the proposed garage. This is the front elevation showing that proposed garage. On the rear, within that area where I showed you there was going to be a gable end, there was proposed to be a Juliet balcony with a full floor to ceiling glazing, and one of the reasons for refusal related to overlooking on that. And this is the reverse, this is the garage, and this is that gable end, which is now hit and reduced in scale. Looking at the floor plans, this was the extent of development previously proposed that has now been pulled back. This is showing that the roof of that now proposed to put two roof lights in what will become the balcony area. And this shows the area where the rear extension has been pulled back. It's been reduced by about 1.8 metres in depth to being 2.6 metres, and as I've shown you on the elevations, the Juliet balcony and glazed gable have been omitted. On the ground floor plans, again, this is where the garage is going to be. It is now to be a parking space, and here this is facing the side of number 7. There is a slight change to the previous arrangement of door here, but there is, as I've shown you, quite a considerable sized window in that location. This plan just shows you where there are trees on the site. Trees in this area are subject to a TPO. The trees on here, some of which will be affected by the development, these trees here and these trees here, have been looked at by your tree officers who have assessed them to not be to warrant retention. As I said, the site is just within the Seaway Avenue special character area, and the application is at committee because of 12 letters of objection which do refer to impact both on residential amenity and harm to that area. As the plans have shown, the scheme has been significantly reduced following the previous refusal. The garage adjacent to number 11 has been deleted, and the parking space has been provided instead and is considered to be acceptable to compensate for the loss of the garage. And the location of that parking space is not considered to have a detrimental impact on the street scene. The rear extension has been reduced in depth at first floor by about 1.8 metres, and there's about a 30-metre separation distance between the properties here to this first floor window that would be serving the new extension. The Juliet balcony has been replaced by a window reducing overlooking. No significant impact is considered to occur to the special character area. There's no loss of TPO or significant trees, and no harmful increase in overlooking to Seawood Avenue. If I can just take members to the conclusion on page 92. The current proposal is considered to overcome the refusal reasons on the previous application, and there are not considered to be any matters which would warrant a refusal of the Planning Commission in this case, and therefore the application in front of you this evening is recommended for approval. Thank you.
We have 3 speakers on this. We will take the speakers against first. The first speaker is Mr. New. If you'd like to come to the table, introduce yourself, and then I'll try and remember to start the clock.
Well, good evening, and thank you for this opportunity to speak this evening. My name is Ray New, and I live at number 7 Freshwater, a neighbouring property. I am representing the views of many objectors, including the 24 households who sent letters, and we disagree strongly with the planning officer's view that this application overcomes the refusal reasons for the 2015 application. The main difference is the proposed garage has been dropped and is replaced by a parking space, but the 2-storey extension to the left remains, and we feel is still too large and still visually reduces or eliminates the gap between number 9 and number 7 when viewed from the cul-de-sac. A simple calculation shows the accommodation volume in the revised extension is 84% of the 2015 plan, a reduction which we feel is not significant. Also, the proposed balcony is still very different to any others in the street and does not fit with the character or appearance of the surrounding area. A key concern is privacy. The Juliet balcony previously proposed is replaced by a large opening window and moved back just 1.8 metres. This makes very little difference in terms of privacy loss, as the window would look directly over the patio area and summer house of the neighbouring garden. Also, if the trees were removed from the garden, and there is nothing to prevent that, the window would overlook directly onto the rear of 32 Seaway Avenue. The planning officer reports there is an existing window on this elevation, but this is smaller, further away, and is a landing window. The proposed new window is twice the size, much closer, and is a sitting room window. The case officer report suggests a condition of grant would be no further windows, the reason being, quote, to protect the privacy of neighbouring premises. The case officer has not visited the privacy affected area, and I would like to point out that if the proposed extension window is allowed, there would be no privacy to protect. If the accommodation capacity in this property is increased and the parking capacity reduced as planned, there will be a permanent parking problem. I'd also like to mention this application, as last time, refers to disabled facilities. We know with certainty from the owner's daughter that the house owner will not be leaving the care home. The applicant knows this. The reason I mention this is that there is a lot of concern over why a single person living in a 4-bedroom property wants to increase the living accommodation with the addition of 2 self-contained living units. However, in summary, on planning issues, we feel this application has not addressed the reasons for prior refusal. The bulk, massing and form of the extension, the size and character of the balcony, the potential for parking problems, and the definite loss of privacy are all issues which we still feel are contrary to local planning policies. We feel the planning officer's grant recommendation is wrong for the neighbours and wrong for the neighbourhood. Thank you for listening to our concerns, and we hope you vote against this application. Thank you.
Thank you very much. We now have Mrs. Loader. If you could pop your microphone on.
Good evening, Madam Chairman and members. My name is Angela Loader. I live at 11 Freshwater Road, next door to 9 Freshwater Road, property that is the subject of this planning application. I am representing the same group of objectors as Mr. New, who spoke before me. There are many issues, concerns, and general unease among residents related to this application, including the declared usage. The design is overly large and awkward. Plot sizes do not lend themselves to such overdevelopment. When viewed from the cul-de-sac, the side extension and new balcony form a dominant and incongruous addition to number 9.
Visually, it will give a terraced effect and impact on the street scene. The property is already situated in a cramped position in the corner between number 7 and 11. The addition of the two-storey side extension is considered to be bulky, intrusive, overbearing and out of scale and character with this property and others in its vicinity. Also, it will entail loss of privacy for the neighbouring properties. In anticipation of the application being approved, the balcony has already been extended out at the front, side and rear and will be trebled in size. It will have a glass balustrade running all along the front, side and rear of it, which will be overpowering and have a significant impact on the street scene and the privacy of number 7 and 11. The number of parking spaces shown on the new plans are less than those currently available, and increasing the accommodation capacity whilst reducing the parking capacity will create an even greater problem. We are also concerned that our planning officials have shown an inconsistency in their interpretation of HE2 and H12. HE2 policy requires residential development be appropriate in terms of scale, character and design to its surroundings. The design, bulk and mass of this proposed extension and balcony would result in an overly dominant development which would sit uncomfortably with its neighbours and would not preserve or enhance the character or appearance of the local area, not meeting policy requirements of HE2 and H12. Please support us by voting to refuse this application. We're looking to you as a committee to restore consistency and our confidence in the local policy. Thank you for listening and giving me the opportunity to speak.
Thank you for coming to speak. We now have a speaker in favour of the application. It's Miss George. Good evening. You've just turned the microphone off. Sorry. That's it.
Good evening, Madam Chairman and Committee. I thank you for extending the meeting to hear this. It is important to me to have this put through, so I will keep this as brief as possible. I believe that the planning department have covered all the aspects in respect of the design, scale, etc. The main reason for adding this to this is to highlight that this was in 2015 a disabled person's adaptation for both myself and my father. He is currently temporarily retained in a care placement, and that has continued since 2015 because his property is not wheelchair accessible, and he was unable to mobilise after the shock of being widowed at that time. So that is the main reason I wish to have a moment to bring that to your attention when considering this application. Thank you for your time.
Thank you very much. We also have the ward councillor, Councillor Hilliard.
Thank you, Chairman, members. The 24 letters of objection from residents indicate the high level of public interest in this highly sensitive extension. As they indicated in the officer's report, a previous application to extend the property was refused by this committee only in August 2015, with the reasons being overdevelopment in a special designated character area, bulk massing form out of keeping with dwellings, reduction in separation from neighbours' properties, impact on street scene, and overlooking loss of privacy, impact of amenities on neighbours. With only minor changes with reductions to proposed extensions, residents believe the committee's decisions should still be to refuse this new application. The new proposed window in the rear of the first floor extension is designated in the plan as a sitting room. The rear window in the existing building is a landing, so it's completely different reason for a room, so someone will be potentially in the room all day looking out of that window, and clearly overlooking will be possible on the main garden area of number 7 and also in the property behind. As we've heard from the residents, the trees at the rear of the property of number 9 are not protected, so there's overlooking now, and it would be significantly worse if those trees subsequently get removed in the planning application. The proposed extension would cause a reduction in the separation gap between properties. This, along with the intrusive balcony in the front, would have a significant impact on the street scene, as this is an area of detached properties and this look would be completely changed. Residents question the motives for a single person living in an already large property. Why is a first floor extension being proposed with a large rear window? This, as I said, this will be used all day long as actual. So people talk about perceived overlooking. This will be actual overlooking throughout the day. We urge the committee to follow the previous decision, as little has changed, and refuse this application. Thank you.
Thank you. Did the officers want to come back on anything before we go to questions? No? Any questions? Councillor Barr.
I remember this application because we actually did a site visit to it, so I know it quite well. A couple of questions. The distance from the window which serves the upstairs lounge to the amenity space of number 7, which when we did the site visit, they've got like their main area for sitting out is at the end, at the back of their garden, at the end on the northern boundary. And I just wanted to find out what the distance of the window is to that amenity space, if possible, please.
It would be in the region of about 15 metres. But it is also at an obscure angle, and it's a very normal relationship to have in a residential area, to have that obscure angle over your neighbour's garden. It's what it happens. It's just a normal relationship.
I'm sorry, I didn't switch off last time. How close would it have to be for you to say that that would be, causing overlooking?
On a side-to-side, a rear-facing window would not be considered to be causing unacceptable overlooking to its neighbouring property, where the relationship is like this. And you'll also pick up that the building here is set further back, so the window would be in roughly this location. So you can see there is quite a considerable difference at quite an oblique angle.
Next question is, the report says that there are quite a few properties in the area with balconies around the front of the property. I just wondered where the closest one to this is.
I don't have the benefit of pictures at the moment, but I believe, and I stand to be corrected, I think this property here has a front balcony. There is definitely one along this part of the road that does.
My final question is to do with the balcony, which is at the moment looking at the front of the property to the right. I believe the pictures that you showed some vegetation there at the moment, the actual picture. Yeah, here. Has that been removed now? Is that's still there, is it? So that the balcony that's behind there already has an ability to look over to number 11. Is that correct?
That is correct. You can see there is some vegetation here. The balcony that was here already has those views in this direction and towards number 11. To form the parking space that is proposed in here, these will be lost.
Is that balcony any closer to the amenity space, the new balcony of number 11, than it is at the moment?
If I can go forward, you can see that this part of the roof currently has that false pitch coming onto a flat roof, and it will now extend up to the edge here. So yes, it will move it closer. It will move it closer to number 11, and there'll be a balcony created in this area here, which has the overview of number 7. But you will notice there is already a window in this elevation.
So the relationship from that balcony over to number 11's amenity space at the rear, have you got that that distance, please?
The extended balcony would be here, so this is number 11. So you can see it has quite a strange relationship. It's looking up the side of the building, and its amenity area sits around it. So it depends where you want it measured. You can see it has quite a direct.
Sorry, I'll switch my microphone on. I can see an aerial view here, so I can actually see that relationship. Okay, yeah, that answers my question. Does that show the where the balcony is at the front?
Sorry, I brought up Google Maps to see if I could identify where the other balcony was. There is one, I believe, around the corner, but not actually. Difficult to identify.
Yes. Anybody else with any questions? Councillor Grace.
I also went on the site visit, so I remember this really well. My concerns last time why I refused it is because of the closeness of number 11. And I still have concerns about that now. I'm looking at the picture with the tree, and will the hedge be removed as well? I think that's a hedge, isn't it? And will it now become up to that? Is that going to be car parking just behind that hedge? It's hard to sort of, or is it going?
On this, yeah, if this plan shows the parking space will come right up to the edge, so yes, this vegetation will go. But this could be done under permitted development. In fact, much of this development could be done, we believe, under permitted development. We haven't looked at it like that because there are elements that need planning permission, but the majority of it could. And the provision of a parking space, subject to how it's going to be surfaced, could be done without planning permission.
Thank you.
Councillor Neil.
Yes, I too was on the site visit previously. When we went on site visit previously, that window that could give overlooking to number 7 was only a landing window, and I think being 12 metres across now would actually makes a really big significant difference at the fact that it's a sitting room. It's a change of use of that window being bigger. And
that question.
Yeah, so that's why I'm just checking that's where I understand.
It's a very difficult measurement to make because you're making it at an oblique angle. I mean, this room here, I think I'm asked to work, is annotated as being a bedroom come sitting room. Quite honestly, the use or how people use the internal of their houses is not a matter for us to consider. This is a single dwelling house and would remain as a single dwelling house because the application is not to subdivide it anybody can use any rooms in their house for any purpose. So I wouldn't take that in. That should not be something that is taken into consideration. It's annotated as such. It may be used as that, but if it is used as that the relationship is absolutely acceptable in planning terms. The back-to-back relationship across to number 32 Seaward Avenue is in excess of 25 metres, and that as a back-to-back distance, as members will be aware, is acceptable.
I was there, and it was a landing, not a room.
The matter to be considered is what the relationship is between the proposal. We've used the landing window to show you what the view is so that you understand what the view is. We're not suggesting that there is parity between the use of a landing window and an upstairs room that could be used for a bedroom, it could be used for a living room, it could be used for a study, it could be used for any purpose that the occupiers choose to use it. So that the purpose of pointing out the landing window was to clarify what the current view is from that window, and the new window will sit 2.6 metres further forward of that. And the purpose is to show you that the separation distance, yes, you will be able to see, but as members will be aware, a separation distance of first floor windows back to back of 20 metres is generally considered to be acceptable, and this is now, as I say, in the order of 25 metres. 15 is the measurement that we were asked to provide in this view across here to the rear end of the adjacent property at number 7, which is this property here. So you can see the side wall here. Right, okay, number 7. It's approximately 15 metres from the new window to
a new large window and a room, not a landing. Okay, that's fine.
I have a question myself. It regards the usage and the permissions that would be required should the usage of the property be changed, and the potential ramifications if those permissions were not applied for.
I'm not entirely clear, but as members will be aware, we don't ever and wouldn't condition the use of any room within a
Sorry,
house.
I meant of the dwelling. So, for example, the usage of the dwelling were it to be split into flats, and the permissions that would be required in order to do that.
If it were proposed to use the house as 2 separate units, then permission would be required. However, you can use the rooms in the house however you wish. There's a subtle difference there, but the only time it would need permission would be as if it was formally split into 2 and occupied as 2 separate units.
Thank you. Do we have any further questions? Then we're going to go into debate, and Vice Chairman, I believe you're the Ward Councillor.
Yeah, I am. I think this is another tricky one, because having visited it and seen the site and understand all the issues that the residents had previously, the previous application, and why we then chose to refuse it, it's difficult now to then see something come back in, which is an amended version of the previous application, and to judge whether actually now they have overcome the issues that we identified in order to refuse it the previous time. And I can quite understand the residents, adjoining neighbours' concerns, because this will be a change to what they are experiencing. But my concern is that if we were to refuse it, I don't believe we have planning grounds to now refuse it. I think they have overcome the issues that were previously raised, and I think we would be giving false hope to the neighbours if we were to refuse it, because I would imagine that the planning inspector would overturn that refusal, because I do not believe, particularly given the answers to questions that I've had from the officers, that there are material planning grounds to refuse this application. And so unfortunately I would have to go with the recommendations that our officers have given us for approval, and I propose approval.
Thank you. Do we have a seconder? Nobody else will second it. I will also second it, due to the fact that I agree. I do not believe that we have any material reasons to refuse this application. It is an improvement on the original application, and therefore I will second it. The application has been proposed and seconded, so we're going to go to the vote. All those in favour of approval, please show your hands. That's 3. All those against approval, that's 1. Any abstentions? There's also 1. That application is approved. Our members, excuse me, we're trying to continue with the meeting here. We're going to go on to item 4G. If members are happy. Who's leading on this one? Off you go.
Thank you, Chairman. This application is before us because it's on council land. The proposal is to install a new storage container alongside on the site. Oh, sorry, pressing the wrong button. It is a long day. The existing containers are there. Space and the sorry, it's not working very well. The proposal is to erect another container just to the right hand side of what you can see there. The bottom picture indicates a caged area currently used for storage and uses that associated with the allotment site. The proposed new storage container would have a similar appearance and size to what's there already. It's about 2 foot shorter, but fundamentally it's the same in a location that's not particularly intrusive. It's reasonably well screened by vegetation. It's far enough away from any neighbouring sensitive uses not to be of any particular nuisance, and the recommendation before you is for approval. Thank you.
Thank you. Are there any questions? In that case, we're going to go into debate, and I shall open the debate by saying I'm happy to propose this as set out. Do I have a seconder? Councillor Grace?
Yes, I'm happy to second this as set out.
Proposed and seconded. All those in favour, please show your hands. That's 4 in favour. Those against? Any abstentions? 1 abstention. That application is approved. Thank you very much for your forbearance this evening, ladies and gentlemen. That was a very difficult meeting.